Court of Appeals of the State of Michigan is now in session. The Honorable Christopher M. Murray, the Honorable Allie Maliano, and presiding the Honorable Daniel MCOA. All persons having business hearing draw near, give attention, they shall be heard. God save the United States, State of Michigan, and the Honorable Court.
Well, good morning, everybody. Welcome to the Michigan Court of Appeals. This is the first day of case call for panel 5 of the December 2025 session. My name is Dan Koropkin. I'm joined here today by Judges Christopher Murray and Allie Maldonado. This is my first time I will be presiding, so I'll be counting on Judge Murray and Judge Maldonado to keep me in line. We understand these cases are important to the litigants and to counsel. We want to assure you they are important to us as well. We've been working very diligently on these matters. We've had the benefit of your briefs, of our research division support and chamber staff, and of course, we ourselves have been through these cases numerous times. So all of this to say, we're familiar with the facts, the pertinent law, and so we'll ask you to focus oral argument today on your most important points, why you think you should prevail, what's critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Now, these proceedings are recorded, so we're going to ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. With that, we look forward to hearing your arguments, and we'll begin by calling item number 1 on the docket, which is People versus Devin Carl Baldwin, number 363-237.
Good morning, Your Honors. Mike Middlestad of the State Appellate Defender's Office on behalf of Devin Baldwin. Mr. Baldwin, Devin's mother is here supporting her son. I just thought I'd point that out. I don't think I'm going to need it, but I will reserve 5 minutes of my time for rebuttal.
Sure, okay. We'll ask that you keep your own time.
Yes, will do. If it's okay with the court, I'm going to focus my comments on the first and the fourth issues that are challenges to the conviction, which is the closed courtroom issue and the prosecutory misconduct claim. And if you had any questions about the other issues, I would be happy to answer questions there. I guess I should start out by responding to Brother Counsel's argument that this is waived rather than a plain error situation. It's not waived. There are 2 comments that opposing counsel relies on. One that was 6 months at a pretrial conference 6 months before trial, and one was as they were getting the jury ready to be called in. Neither one of those is the clear expression of satisfaction with the courtroom closure that was going to take place. And that's the standard that People versus Davis said. There has to be a clear expression of satisfaction with the manner in which the action which the court is proposing. 6 months before trial, the trial counsel merely said, "I am happy that we are not in full pre-COVID mode." That's certainly something that, saying that he's pleased that we're not doing things the way we did in 2019 is not the same as saying, "I am in favor and I am happy with Your Honor's proposal to restrict access to the courtroom." And I think the statements on the eve of trial or just before jury selection are even more vague. All he does is really just point out that there's been some COVID cases and that he's happy that there's a mask requirement. And there's nothing in there that's a clear expression of satisfaction with the procedure that the judge was following in this case. So we, as you know, we do have the Davis standard applies. Davis has modified the Carinas test so that the third prong is automatically established when structural error is established. And then there's a rebuttable presumption that the fourth prong is established. I'll just try to run through those factors with you here. We've got a plain error in that there was a courtroom closure. The judge made unequivocal statements in his ruling, saying that he had to take measures to accommodate the COVID separation requirements. that really did not exist at that time. And that any decision as to who would be let into the courtroom would favor the victim's family. That, in my opinion, that places the Crime Victims' Rights Act above the defendant's right to an open trial, open trial there. So pages 286 and 287 of jury selection, there's also comments made that indicate that there's going to be exclusive participation by the observers from a remote location via video. And then we, at page 7 and 9 of volume 15 of the transcript, we've got a clear indication that members of Mr. Baldwin's family were not able to attend personally, and that even some of the victims' families, or maybe even all the victims' families, were required to attend from a remote location. So that's plain error off the bat because the judge didn't follow the procedures that Presley and his progeny requires. The judge has to follow make findings on the record, consider alternatives, and, there has to be a compelling interest that will be prejudiced unless the court takes actions to restrict access to the courtroom. And none of that was done in this case. The case law says that the appellate court will find a public trial violation based on the mere failure of the trial court to jump through those hoops.
Can I ask, I don't know if you came across, I'm going to ask you about an unpublished decision.
Yes.
But it's People versus Michelle Renee Lyon.
Yes.
And the reason I'm bringing it up is because it's the same judge, same court, just a couple of months. I forget whether it's before or after. I think it's after. And that panel, unpublished, so we're not bound, said it was error, but then said it was not plain error.
Yeah.
If you're familiar with that, what would you like to
Yeah, in fact,
say
I
about
listened to the argument last night. And there's another case, People versus Sherrill,
Yes.
and that went up to the Supreme Court, and there was a dissent from one of the justices there. With all due respect,
So they
to that,
denied leave in it, is what you're
they
saying?
denied leave over
A dissent to a denial, okay.
over objection, over dissent there.
Okay.
So,
Means
and I
nothing.
can distinguish the facts of that case if you'd like me to. With all due respect to the panel in that case, I think they just got their analysis wrong, and they got their analysis wrong for a couple of reasons. They said it was not plain error, but really what they were trying to say, because if it's either it's error or it's not, right? They found an error and they found it was clear and obvious. What they didn't say was, well, it really wasn't a constitutional violation because of all these other things there. So I think that kind of muddied the Davis analysis that was required, because once you find clear and obvious error, you then jump to prejudice. And as we know, we skip prejudice because that's been established, and then we jump to the fourth prong. They didn't really go through those hoops in that case. They put a lot of emphasis on the fact that there was not an objection. So they sort of double counted the failure to object by applying the higher standard of plain error, and then by also saying, well, this factors into the Presley analysis, and that must mean that there really wasn't enough here to require reversal. So I think, like I said, with all due respect, and I think there were reasons. Now I take that back. There was evidence in that case, though, that there had been a spike in COVID cases, although I don't really think that was all that well founded. But the court in that case did rely on comments by the court that family members of the prosecutor had COVID and that there had been a recent spike.
I mean, I guess it raises the question of what in the plain error, when is it the case that an error occurs, but it's not plain?
Yeah.
That's kind of I think we don't see that a lot.
Yeah. Yeah.
Usually the two go together.
Yeah. It's my position that the closure of a courtroom, and I think this is where Leon or Lyons got it wrong. The clear and obvious error is the plain error. And then you go to the third and fourth steps. And the closure here is a clear and obvious error. Does that make sense? I don't know if I answered your question or not, Judge. So now I know there was a contention both by the trial court and by brother counsel that using video was somehow ameliorated the closed courtroom violation. That is not consistent with the spirit of the public trial requirement. The public trial requirement serves multiple functions. One of which is a personal right of the defendant, and that is to have his family and his supporters there personally with him. That is a personal right to the defendant that is diminished by removing those people physically from the courtroom.
Are there any cases where during COVID restrictions, but trials were held, that a court found that there was a public trial violation when people were not allowed to sit in the courtroom and watch?
No, there is not, Judge, but those were at the, I mean.
I know, but I understand that.
Yeah.
That's why I was asking, because
Yeah.
what we have here, it appeared to me when I read it, was a judge who admitted he was extra cautious,
Mhm.
and even though the other judges in the circuit weren't doing it anymore, he still was going to protect
Yeah.
everybody.
Right,
So you're like, okay, well, there were people like that
yeah.
doing things, and so it's just hard to say, well, if it was allowed during the height of COVID,
Mhm.
but now one judge continued a little bit, but made some accommodations, because these people weren't streaming from their living room, they were in the courthouse in I think they had two different rooms because people weren't getting along or something, or they were worried they weren't.
They
going
were
to.
worried about that, yeah.
Yeah, I mean, that's what makes it hard to say that, well, it was okay then, but on the couple of stray ones or leftover ones, I would say, I guess, that it's now a constitutional violation.
Two things, Judge. There has to be a compelling overriding interest that will be harmed unless measures.
I
are
agree.
taken.
I agree it was an error for him to do this.
Okay, thank you.
But it's the prejudice part. I mean,
It's structural error. You don't get to prejudice. Davis says that straight flat out. You don't get to prejudice. Now,
well, what's the fourth prong?
the fourth prong is a presumption that the fairness, integrity, and public
Right,
reputation.
right. So, but yeah, you got to overcome the presumption.
And I don't have to overcome it. It's their burden. And they haven't even attempted that in their response. There was no attempt in the response at trial court. There was no comment by the trial judge. In fact, the judge found no closure at all. And there has been no attempt to overcome that presumption on appeal. So with that said, with no effort, I mean, usually when one party has the burden of proof and they don't even attempt to overcome that burden, I think that the result is the other party prevails on that. So we've got prejudice and we've got an unchallenged fourth prong that the fairness, integrity of this process of the proceeding was undermined there. So I can move on, or if you have any questions about the interplay between video participation and in-person participation, why I think that doesn't satisfy the public trial right, particularly under these circumstances. Again, the right is personal to the defendant, and the right is to have people physically present supporting him. That wasn't done here. The right is there to shed daylight on the proceedings so that everybody's reminded that they're under scrutiny. When you have a remote, just a camera in the corner of the courtroom, you don't have that reminder to everybody in the courtroom that the public is watching them. You don't have any kind of an indication that there is the daylight needed. Now, opposing counsel relies on a Second Circuit case which seems to indicate that the use of video transmission did not violate the public trial right. Number one, I don't think that's good enough just to have it one way. I think it's got to be two-way. There should be at the very least, there should be a screen on the wall that reminds everybody in the courtroom constantly that they're under scrutiny. And at the very least, I think there needs to be a reminder to the jury from the judge that this is being streamed publicly and that the public, they're under scrutiny. And I think in that case, the Second Circuit case, there was a specific instruction from the judge that the courtroom was being watched and the public did have access to it. Most of the cases, I don't have them in my brief and I can cite them in a supplemental pleading if you'd like. There are several cases that talk about reach conclusions that the accommodations made with streaming of the court trial proceedings was enough, but all those had interactive, all those had two-way, where the jury and the participants were constantly reminded that there was somebody out there watching. And many of those had a jury instruction that did the same thing, served the same purpose. So unless the court has any other questions about the closed courtroom issue, I'd like to move on to the prosecutor misconduct claim there. Again, I have to respond to opposing counsel's claim that this was somehow invited, that it was a fair response. I think this is a clear example of the cliched saying that we see from a lot of the case law where hard blows were met with foul blows. This was not a fair response to anything trial counsel said in his closing, what we had from the prosecutor. Yes, I concede that defense counsel was glib, defense counsel was derisive, defense counsel used coarse language in challenging the arguments made by the prosecutor, but they were focused on the arguments. They weren't focused on the motives and the character of the prosecutor. They didn't imply or at least explicitly say that the prosecutor was trying to do something untoward. And then if you go to the prosecutor's rebuttal, it was just riddled from start to finish. Every single thing he talked about was he's trying to pull the wool over your eyes. I think one of the most egregious examples is when he talked about there was a dispute during trial over whether all of audio of a witness statement should be played or only specific portions of it. Defense counsel only wanted to play specific portions of it, leaving it to the prosecutor to do it, to complete it under the rule of completeness. The judge came back after a sidebar and said, no, you got to play the whole thing. And the prosecutor pointed to that and said, look, he's even trying to get you to not hear admissible evidence. And the judge agrees. The judge agreed that he was trying to hide the ball on you guys. And so that's particularly egregious because that shows that there's a judicial imprimatur of, hey, this guy's being shady. Throughout the argument, there was claims that he was doing this for the sole purpose of fooling the jury. And I know from every family gathering I've been to in the last 25 years that lawyers have an image problem. And so he walked into that courtroom, with that sort of stigma hanging over his head that defense lawyers are there just to be hired guns, and they're there, they don't care. They know their client's guilty and they're just trying to get him off. And this just reinforced that. And it reinforced the fact that the judge viewed the defense attorney that way. I think it's plain error requiring reversal. It's prejudicial. Certainly the fourth prong, we're getting back to the fourth prong, the fairness and integrity of these proceedings was undermined by what the prosecutor did. He spent an hour, 45 minutes doing nothing but questioning the integrity and motives of defense counsel. He had the last word. It was on rebuttal. So there was no response to that. And clearly there was prejudice here. And the prejudice is the case was pretty close because you had one-time co-defendant who got off a pretty sweetheart deal to testify against Mr. Baldwin. You've got clearly a beef between victim and one-time co-defendant. We've got, social media, and we've got text message exchanges where they're talking about using violence on each other and revenge. We have the one-time co-defendant who was in some sort of love triangle, or at least in the mind of the deceased, some kind of love triangle with the co-defendant. And then we have a group of people, all of whom, all of those witnesses who testified against Mr. Baldwin were affiliated with the one-time co-defendant. Mr. Baldwin was sort of the outsider. He was sort of the interloper here. He was new. He was relatively new to people. And, they were all kind of drug induced and drug addicts, and they had incentives to favor the prosecution. They were all giving pretty good deals, especially the one-time co-defendant. So this is a pretty close case. And when you have a prosecutor totally undermining the Sixth Amendment right to counsel by saying that this guy that you've been listening to from jury selection, from opening argument, from cross-examination to closing argument is just a shyster that is trying to pull the wool over your eyes, that knows his client is guilty and is just trying to get you to not look at the real evidence. So with that, unless the court has any other questions, I'd ask that you reverse Mr. Baldwin and reserve the rest of my time for rebuttal.
Thanks very much.
May it please the court, Jerry Scrotenboer, Bingham County Assistant Prosecutor for Plaintiff Appellee. Going to the first argument. No, there weren't 2 comments. There were 3 comments. Defendant is missing one. In the final pretrial, just before orals, just before the trial, counsel noted that some county offices had come down with COVID. So we're talking 3. When you add them all up together, that sure sounds like a waiver. Now, plain error? In the first place, the cases say that there's no problem here. Defendant doesn't come up with a single case, published case, that says this is incorrect. Now, for plain error, yes, actually there is a difference between error and plain. Plain has teeth in it, as the Sixth Circuit has said, and it requires a case to be on point. And there isn't any. He's just coming up with analysis that is appropriate if the issue were preserved, but it is not preserved.
Are you saying there's no case on point because there was there were COVID-related facts? Because
Yes.
I mean, there are lots of cases pre-COVID, right, where
Oh, certainly.
this would be reversible.
Certainly.
Okay.
And that also gets to the next point. Defendant presents absolutely no evidence that it in fact was safe at the time. He just says, oh, COVID was over by that time.
But weren't all the orders, local and state, all expired or rescinded?
Yes, by that time, yes.
All right, so there's no authority to rely on to say that the courts need to continue operating the way it did during the pandemic.
It's not required to, but he may. And the Lyon case, incidentally, the Supreme Court denied leave with no dissents on that one. Now, when you add these things together, the published case is saying no problem.
The published cases say no problem during the pandemic while the orders were in effect. You don't seem to think there's much of a difference between the two scenarios. You just told Judge Koropkin if this happened pre-COVID, it'd be a big problem.
Yeah, it might be.
Now this is post-COVID. Why isn't it a big problem?
I'm entirely sure it's post-COVID, but
It
Okay.
is. Look, if you look objectively, it is because all the orders, the governor's orders, the Supreme Court orders, any local
Yes.
orders were all expired. So it is.
that's
post-COVID.
correct. But that's not quite what the cases say. The simultaneous video and audio access available in nearby courtrooms ensured public access to the proceeding, thereby safeguarding the values the Sixth Amendment is aimed to protect.
This is the Lyon case.
No, that's U.S. versus Hunt, Second Circuit. That's right. And I also cite a Fourth Circuit case and a Tenth Circuit case that say that. But when you add all of these together, that defendant doesn't have a case, certainly no published case, and the cases go the other way, the system's integrity is not violated. The fourth prong is met here. Let's go on to the next issue.
On the,
Oh, sure.
on the fourth prong, your opposing counsel talked about it being your burden.
Yeah,
Is that what kind of burden is that? Is that a burden of proof or persuasion?
I assume that it would be a burden of persuasion.
And your argument is simply that there was that there was video, it wasn't two-way, but there was a video feed.
Yes,
Okay.
that's the first thing. Defendant doesn't have a single case that basically says that this is a problem. And there was evidence of COVID outbreaks at the time. And of course, add to it trial counsel statements at the time. You add all that together, and the fourth prong, defendant, it has the system's integrity is not compromised by not reversing. And besides, we all know very well that it had nothing to do with the jury's verdict. Anyways, going on to the fourth argument. When you really come down to it, as the cases have said quite often, no instruction would have cured it. And defendant doesn't really address that. And I just sort of made up an instruction. Both of the lawyers have improperly impugned each other. You are to ignore the personal attacks. This trial is not about who flings the most insults at each other. Instead, you are to decide, based on the evidence, whether the prosecution has proven guilt beyond a reasonable doubt. Otherwise, I will have to declare a mistrial. You must disregard the unprofessional comments. Now, the comments are basically the same. If we take a look at various things,
What were you reading from, please?
my brief,
That was directly out of your brief?
yeah,
Okay. What page?
well, it's the last page of argument 4. Let's see now. In closing, counsel said, for you to take that great pile of physical evidence and actually in your head turn it into something that allows you to be so convinced as Mr. Stevens, that's making it personal, desires you to be, is you've got to believe these dirtbag witnesses who have come before you. Now, that's personal. Yes, prosecutor should not have said those things. Yes, that is correct. But this is not a hard argument followed by a foul one. This is a foul argument followed by a foul one. Essentially, it is not manifest injustice to not reverse for something that wasn't objected to, where defendant did the same thing. And he really did. If you compare both together, they're of a kind. And when you do that, you come up with that. Yeah, even that old case, People versus Wise, to an equally or more improper argument by defense counsel. It's basically the same thing. Yes, the U.S. Supreme Court said it better the next year in Young. Let's see, the opinion came out in 84. I was only 28 when I wrote Wise, so what do I know? But anyway, it's not manifest injustice. Yes, there's error. He should not have said those things. But it was of a kind that defense counsel had made. And that makes all the difference. And besides, let's not forget the failure to object actually kind of matters here. It kind of shows that defense counsel, who could have objected to all these things, it shows he didn't think it was prejudicial. And there's no claim of ineffectiveness on this one. When you add it together, there's no plain error. Or nothing requires a new trial for these two non-preserved issues. I ask the court to affirm. Thank you.
I will take the arguments in reverse order. The argument that brother counsel points to say it opened the door to all this, all this personal attack was defense counsel saying that the witnesses were scumbags, dirtbags, or whatever he said. The response was trial counsel's a dirtbag, basically. He didn't say dirtbag, but in so many words, he said he doesn't believe his client. He's trying to fool you. He's a dirtbag. Throughout the entire argument, he was a dirtbag, at least in the rebuttal portion. With regard to the jury instruction that Mr. Schrotenberg proposed would have solved the problem, there's two problems with that. I'm pretty sure, and I don't have a cite for you off the top of my head, but I don't think a judge can warn the jury that there might be a mistrial. I know it's certain circumstances when they're hung, the judge can talk about maybe we're going to have to dismiss you and start over, but to hang this over their head to say that there's a mistrial possibility, unless you ignore this, I don't think is proper. And number two, basically that instruction says, number one, it's not warranted because it doesn't talk about, there wasn't a both sides. There wasn't a whataboutism in this case. So that instruction covers defense counsel and the prosecutor. So that doesn't help. And number two, if you do tell the jury, hey, both these guys are dirtbags, just, don't pay attention to much of anything they said in their questions, in their opening, in their closing, in their voir dire statements. Just kind of go by what you think, and don't listen to their arguments, disregard them. And that's basically what that does. And that it sort of undermines the presumption of innocence, because we have an adversary situation for a reason. We have both sides zealously advocating for their side and arguing why inferences should be drawn and why witnesses should be believed or not believed. And if you take all that off the table, the jury is essentially just left with not really much of a roadmap other than the judge's jury instruction. To the first point, I don't think the plain error standard requires a four corners case. And I don't have the site, and I know it's in a different context, but the Supreme Court has held that under the habeas standard of clearly established law, a subsequent decision that comes down can constitute a violation of clearly established law. And I think that's somewhat analogous to our situation. Again, I'll be happy to supplement with that site, but that's somewhat analogous to the plain error situation. If all the dots add up, if this new set of circumstances fits within a certain area of existing law, it is plain error. And we contend that that was the case here. There's a case that says there's a presumption of openness. There's a case that says that when the judge wants to limit the access to the courtroom, that the judge has to jump through the four hoops that Presley requires. And there's a case that says, there are cases that say that it has to overcome, the decision to close has to overcome a significant burden of showing that bad things are really going to happen unless we take action to limit access here. All those were not followed in this situation. Again, the judge didn't even try. The judge relied on a 6-month-old or a 1-year-old rule that was completely outdated. So with that, yes, Judge, COVID was over. COVID was still a public health crisis. COVID still required, measures to be taken. But I think the fact that other judges were doing things that gave more weight to the public trial right, that accommodated the defendant's family, that allowed the public to more access to the courtroom, shows that this was not an overriding interest. This was the judge's, the judge's motives may have been completely commendable, right? He wanted to protect the health of the people. He just did it at the expense of Mr. Baldwin's public trial right. Thank you.
All right, that case will be submitted. Calling the next case, which is item number 2, People versus Howard Shane Hector, case number 368501. I think we have remote oral argument from the appellant, and looks like Mr. Simon is coming on.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Hector. I would like the court to focus on, I believe it's argument 2 of Mr. Hector's brief. We believe that the improvised instruction, I think that the court gave in response to a question from the jury, pretty much directed a verdict of guilty on both the reckless driving causing death as well as the operating while impaired causing death. And we believe that in addition to the other arguments, that this matter should be reversed and remanded to the Ingham Circuit Court for a new trial.
Anything else from our panel? No? Okay, thank you, Mr. Simon.
Good morning. May it please the court, Elizabeth Allen from the Ingham County Prosecutor's Office on behalf of the plaintiff appellee. I will just focus then on argument 2. And I think to first really look, we have to look at what the judge actually said, which was, so the jury asked a question, basically asking, can we consider the evidence of intoxication in evaluating the reckless driving causing death charge to find willful or wanton disregard for the safety of persons or property? And the judge responded, and you have to look at all the sentences he said. And you can tell from the transcript that defense counsel wanted one instruction, the prosecutor wanted another, and the judge said, okay, let's cover all the bases here. So he said, the overall instruction about evidence is all the evidence that you believe should be considered in reaching your verdict. Fine. So the first question is, if you believe evidence of intoxication while the defendant was driving, and if you believe it shows willful or wanton disregard for the safety of persons or property, then it is proper for you to use the evidence of intoxication to show that element is established. So he puts it right back to the jury who is to decide these facts. If you find intoxication while driving, and if you find it meets that standard, then you can use it along with all the other evidence to decide that an element was established. So in no way does it tell the jury that an element has been established. It basically restates the jury instructions as to what they are to find. And the if statements are all there to explain to the jury what their job is. And when we're looking at the standard, which would be whether or not the instruction removed from the jury the factual determination of an element of a crime, that did not happen here. And so we'd ask this court to affirm, but I'm happy to answer any questions the panel has on any of the other issues as well.
Okay, thank you very much.
Thank you.
Anything in rebuttal, Mr. Simon?
Judge, these instructions are considered at length by panels of lawyers and approved by the Supreme Court. The jury was instructed on both of these crimes, and the court should have referred the jury back to the instructions, which they had a copy of in the jury room. And I don't believe that the explanation, which, as Ms. Allen has indicated, sought to, I guess, please or perhaps displease both the prosecutor and counsel, I think ended up pretty much causing more problems than it solved. And with that, I also would ask that the court has any questions regarding that or any of the other arguments which were raised.
I don't think we do. Thank you very much, Mr. Simon. This case will be submitted, and you can stay right there because our next case is item number 3, case number 371232, People versus Terry Lee Horn. And Mr. Simon, if you could just give us a moment to allow your opposing counsel to come up. Okay. All right. Whenever you're ready, Mr. Simon. Thank you.
Yes, counsel is right. I was relying on the transcripts, and apparently the video does indicate that perhaps there may not have been a confrontation issue. It does appear that that there was an ability to see and evaluate the credibility of the witness. The good news is that they agree that this matter should be remanded for concurrent sentencing.
Any questions on that one?
No.
Okay, I think we're set. Thank you. Ms. Proop?
Thank you, Your Honors. May it please the court, Ashley Prue on behalf of Plaintiff Appellee. I will only be addressing issue 1. I believe our brief speaks for itself with the waiver argument, but I did want to highlight just one key point in case this court deems the issue not waived. But the facts of this case are nearly identical to People v. Williams and People v. Hanks. And so those are 2000 and 2007 precedent of this court. The cases that were relied upon by defendants' counsel were actually considered in People v. Hanks, the Fifth Circuit cases. So I believe it's pretty clear that this was not an anonymous jury issue. In fact, the question from the bench, anyone's cousin or stepmom on the jury, anything like that, in open court on the record before the jury was called, suggests that the parties had the names in their packets, and at the very least they had the biographical information and other identifying information that allowed effective voir dire. And unless there are any questions, I would rest on our brief.
I mean, what do you make of the fact that Williams and Hanks, the court basically says, we really urge, I forget the quite the words they use. Basically they said you shouldn't do this unless there is some sort of reason to do this. And then they went on and affirmed. So maybe that's just what we have to do here too. But it seems like the court in both of those cases was saying, like, you shouldn't do this unless there's a real reason to have the anonymous jury.
And then
So-
also, doesn't it go forward and say, if you do it, you need to give an instruction? So it doesn't prejudice the jury?
Your Honor, I don't believe it's a formal jury instruction, but the cases do suggest that the jurors not have an indication that this was out of the ordinary, which did occur in this case. When the jury was called, there's actually, this is in my brief, but the jurors were told that they were being referenced to them as numbers for a logistical purpose of using the computer software to pull them through the system and to not yell their names out in court. So there's no indication that there would have been prejudice to this jury that said, we think this is a extra egregious defendant that you're not safe. There was none of that. This was standard practice, and it was explained to the jury why they were being referred to by numbers. So there was just simply no prejudice here. And then it really gets back to the standard. The issue was waived. The court asked both counsel that said, the plaintiff, the people said we defer to the court's judgment. The defendant indicated that there was no objection. So there is that waiver, which we articulated in our brief for one, but also that means that there's the plain air standard. So there must have been a prejudicial effect. The evidence in this case was overwhelming, Your Honors. There was both, victim testimony and a confession that was provided to the jury. So there's just not that prejudicial effect needed, even if you do determine this was error, but I do not concede that point. This was not plain error. But also there's just not that prejudicial necessity there to overturn it. There was not an actually innocent defendant convicted in this case. There was not a question of the credibility of the judicial system in this case. So it just doesn't get to that plain air standard. Are there any other questions?
I don't think so.
Thank you so much, Your Honors. Have a great day.
Mr. Simon, any rebuttal on this one?
Well, we believe that it is plain error. I mean, certainly these are not quote unquote anonymous jurors. I mean, there is a questionnaire that is provided to counsel, and they know names and they know who their spouse, well, what their spouses do, what they do. Um, so the term anonymous is kind of like a generic term. I don't mean it to indicate that we don't know anything about these people, but these people need to know why they're being referred to as numbers. And I don't know that this brief explanation at the outset is sufficient. When we have a person charged with these very serious crimes, and the juries perhaps need to know that it's not for their protection from my client. It's just a matter of court protocol, and perhaps court protocol should change. And I think there may be an instruction in the offing, so hopefully this won't occur in the future.
Anything else? All right. Thank you very much to both of you. This case will be submitted. Item number 4 is People versus Darab Maywan Jackson, case number 371783. And I believe both attorneys are here remotely. So just give us a second to make sure we have both attorneys online before Mr. Simon begins.
Good morning, Your Honors. Can you see me?
Good morning, and we can. Can you hear us?
Yes, thank you.
Mr. Simon, you're for the appellant, so whenever you're ready.
Yes, thank you, and may it please the court again, Jonathan Simon on behalf this time of Mr. Jackson. And we have a problem with the Fifth Amendment taken by his mother, the owner of the gun. Certainly there is a Fifth Amendment right, but I think that it must be established that there is a Fifth Amendment right in this particular case, and that I think involves an explanation of what that self-incrimination may be, and we have none of that here. We have somebody saying, "I'm taking the Fifth," and they say, "Oh, okay." And I don't think it works that way. You have to present a legitimate reason that you're going to deprive my client of his right of confrontation, that you're going to deprive my client of his right to present a defense. And just because she says, I'm taking the fifth, or the attorney says, I've advised her to take the fifth, I think without explaining what that risk of self-incrimination involves, and that it is legitimate risk of actually presenting herself with the potential of criminal charges, that we need more and we don't have more. And for that reason, I think that Mr. Jackson was denied a fair trial, and we respectfully submit that he should get one. Thank you.
Thank you, Mr. Simon. Ms. Jory?
Thank you, Your Honors. May it please the court, Katie Jory on behalf of the people. Your Honors, defense counsel did not object on the record or in any way, shape, or form to Ms. Jackson taking the fifth. In fact, he was the one who arranged for her to have counsel. He informed the court earlier on in the day that he had contacted a different attorney to come to court to speak with Ms. Jackson in order to counsel her on whether she should or had the ability to take the fifth. And based on the very brief record that was made regarding her taking the fifth, it seemed as though all the parties expected this. And because there was no objection, it's plain error analysis. And I do not believe that this affected the outcome of the lower court proceedings, especially since there was an enormous amount of evidence against defendant. Ms. Jackson in this case did have a reasonable basis to fear incrimination from questions, and it could have lended weight to the prosecution if she invoked those rights on the stand. Could the visiting judge have made more inquiry? Possibly, but I think based on what was known about Ms. Jackson, about it, the gun being registered to her and her son, who was a felon, allegedly being in possession of the gun, that it was pretty well understood by all the parties why she was pleading the fifth. And again, I don't think that defendant, I'm sorry.
I'm sorry, Ms. Jory. Could you explain it to us a little bit more clearly? What was the possible criminal exposure that Ms. Jackson would have had she testified? I believe it seems from reading some of the testimony of the defendant that the purported testimony was going to be that that Ms. Jackson was going shopping or something that day. Ms. Jackson was out and about, and she had the gun with her. What is I guess I'm just wondering because it wasn't articulated on the record all that clearly, what was the potential criminal exposure to Ms. Jackson had she testified?
Thank you, Your Honor. You're correct. The defendant did testify that it was his mother's registered gun and that she had been over at his girlfriend's house earlier in the day because she had went shopping and was paying bills, and she generally carried a gun on her in order to protect herself when she carried cash in order to do those things. I think that the inference based on the record, and again, it was very brief, was that the gun was registered to her. The girlfriend who called 911 said that this is his gun. I know his gun, and described it 9mm black with a gold or brown bottom for the magazine. And so the inference was essentially that his mother bought the gun, registered the gun to herself, and then provided it to her son, who was a felon and should not have been in possession of firearms. And so I think that's why all of the parties expected her to take the fifth. And that was the inference. But again, as you know, the record's very brief.
So she would have potentially been an accessory to felon in possession?
Correct.
All right.
Your Honors, I just also want to make mention that defendant was not denied the ability to present a defense. He did testify to essentially what the mother would have said. He also said that he did not have a gun in his possession, which was a full and complete defense. He does have a right to confrontation for witnesses against him, but his mother was supposed to be his witness. And again, based on the testimony of the police officers, the body cam video, the police car video, there was plenty of evidence in this case to convict. And so I don't believe, based on the plain error standard, that it affected the outcome of the lower court proceedings. So unless there are any other questions by this panel, I would otherwise just rest upon my brief and ask the court to affirm.
Okay, thanks very much.
Thank you.
Mr. Simon, any rebuttal?
Yeah, I think that, that we're engaging in inference upon inference as opposed to, as to what these reasons may or may not have been, that there maybe possibly could have been some kind of criminal liability. We just don't have any of that. I mean, there may be an issue about whether or not he has a right to confront witnesses for his own defense, but certainly he has a right to present a defense, and that's constitutional in nature. And the people must prove that the error is harmless beyond a reasonable doubt, and I just don't think that they have done so in this case. Mr. Jackson certainly has the right to. Mr. Jackson to testify, and he did, but certainly I think a jury would want to hear from the gun owner, and there's where the prejudice lies. All they have is just what would, I guess, be described as self-serving testimony of a person who's on trial for a crime, says, look, this is what happened. But without the person whose gun it was, I think we do have an issue of prejudice, and we do believe that it was not cured. And we respectfully submit that a new trial may be in order.
Thank you very much. That case will be submitted.
Thank you, Your Honors.
Thank you, Your Honors.
So we are moving on to item number 5, People versus Dakota Chase Garcia, case number 367656. I know we have Mr. Herskovich remotely, and we'll just give Mr. Candela a moment to be situated. All right. Mr. Herskovich, please proceed whenever you're ready.
Good morning, Your Honors. David Herskovich appearing on behalf of the defendant appellant, Dakota Chase Garcia. I would be remiss if I didn't congratulate Judge Koropkin on your appointment to the bench. I look forward to trying to convince you of due process violations for the foreseeable future. As it regards this case, I want to focus on the Brady violation issue number 1. There is no argument made by either side that the Facebook records were not, or I'm sorry, let me rephrase that. Neither party will argue against the fact that the Eaton County or the police department in this case had the Facebook records for well over a year. Nor is there an argument that the Facebook records, while requested, were not turned over until after the jury had already started deliberating, meaning that the proofs had concluded. Now, within these Facebook records is a message, an exculpatory statement, which admittedly is followed up by a second statement, but nonetheless, the statement was important enough that it was placed into a police report provided to trial counsel literally the night before trial started. So taking that into combination with the fact that documents that are requested that are over 1,500 pages of Facebook records are not turned over until the jury has already been given their instructions and has begun deliberations is, in our opinion, a serious due process violation. And it should be noted, Your Honors, that due process isn't just a technicality. It's the fundamental right of a defendant to defend themselves with evidence that can be helpful to them if that evidence is timely turned over. And when it's not, that opportunity is stolen from a defendant. It's our contention that's exactly what happened here, that defense counsel was stolen the opportunity of investigating the parties involved in the conversation, interviewing the non-complaining witness, finding out what she might have known, but because none of this information was provided timely, the ability to do so was taken from them. Again, we feel this is a clear violation. If it was material enough to be in the police report handed to defense counsel, then how is it not material to guilt or innocence in this case? We would ask that the court find that this was a due process violation. And frankly, to me, it's very problematic, almost offensive, that this information was turned over as late as it was. And I think the court should definitely be taking that into consideration, and we would ask that they do so. Beyond that, I would rely on the brief and reserve any time I have left for rebuttal to whatever brother counsel might argue.
Anything? Okay.
Morning. Excuse me. Good morning, Your Honors. May it please the court. Christopher Candela appearing on behalf of the Eaton County Prosecutor's Office. I'll keep my arguments to the Brady violation regarding Facebook records as well and rely on my brief for the remaining arguments. I think the fact that the text message or Facebook message was included into the police report is not really relevant to the analysis here. What a police officer chooses to include in his police report. I mean, majority of the time we hope that police officers are including all of the information they know from their investigation into police reports, whether it is ultimately deemed relevant by the attorneys of the court, because that's important for the people to be able to make a determination on charging and how best to proceed on these types of cases. The reality about these messages is that while the first message in and of itself may appear to be exculpatory, when you read the next message that comes 38 seconds later, it's clearly qualifying that first message and saying that that it was somebody else in the vehicle that Taylor was in that shot him, and that is consistent with what his testimony was at trial. It's consistent with what he told paramedics at the scene and law enforcement throughout the investigation. So really this message, if it had been brought in, would have actually corroborated and supported the victim's credibility in this case. And
Well, the second one would have, but the first one, wasn't that a prior inconsistent statement?
I think in and of itself it would have, but we can't look at that message just in a vacuum because it's...
But defense counsel would have been allowed to impeach on that prior inconsistent statement as long as both statements came in, right?
I don't know that it would have really been impeachment, given the fact that that statement really isn't a prior inconsistent statement. It's an incomplete statement by the victim that is completed 38 seconds later in the exchange. So in that regard,
So you think if the defense counsel had that and had tried to use it for impeachment, that would have been inadmissible, that they wouldn't have been able to do that?
I think it certainly could have been admissible evidence. I just don't think that it was exculpatory or material at all, because it's really not an inconsistent statement. It's actually completely consistent. When you take the entirety of that conversation, which is a very short conversation, it's consistent with his statements to law enforcement, paramedics, and testimony at trial.
Can you remind me if the record explains the delay in turning over the Facebook messages?
The record's kind of vague on it, and I discussed this matter with the trial attorney. His recollection is that he believes he turned a DVD containing or some sort, either a USB or a DVD containing these Facebook records over to defense prior to trial starting. Unfortunately, I can't find anything to back that up or verify it. So I have to rely on what I can point to in the record, and there's really not an explanation of why this information didn't get turned over beforehand, or if it did, where it went. So I don't dispute the fact that this should have been turned over prior to trial, but Brady requires evidence that is exculpatory material to be turned over, not every piece of evidence that the people have in their file.
So I was looking at this. Certainly it has to be material in order to reverse the conviction. But I think in terms of that second prong of Brady, it's either exculpatory or impeachment. And it seems like the first message was impeachment, may not have been extremely valuable, given that 38 seconds later, the witness says something else. But it does seem like it's impeachment, and then you get to materiality. At least that's the way I've been looking at it.
Sure, and I think that's the correct way to view the analysis. And so even if we had a piece of evidence that, as you interpret it to be impeachment, or that it was exculpatory, if it's not material, it's not a Brady violation. You have to satisfy both of those prongs. And in this case, as I said, I don't believe this to be impeachment as much as just an incomplete statement by the victim. But it certainly is not material, because it wouldn't have changed the outcome of the trial. It would have corroborated the exact information that the victim testified to at trial. Counsel points out in his brief that what makes this material is potentially the unknown of what could have been discovered had the trial counsel known to go and interview this third party. The problem is there's been nothing provided to this court to suggest that anything would have come from that investigation. So we can't say that something's material based on speculation that, maybe something would have been discovered if an investigation had occurred. Counsel had provided something to this court that says, yeah, had they interviewed this witness, X, Y, and Z would have came out. That may be a different analysis. But in this case, the testimony, the evidence corroborated the victim's testimony and the remainder of the evidence in the case. And so in reality was not material and not exculpatory. It was actually beneficial to the people. And I think had my trial attorney known that text message was in there, whether he did or not, I believe he would have brought it in himself if he was aware of that message. Otherwise, I'll rely on my brief unless the court has any questions.
Thank you very much.
Thank you.
Rebuttal?
Just something quick, Your Honor. I found a good quote the other day while doing research on this. I think it's important for the court to hear it. A trial is designed to be a competition of facts and arguments, but it only works if both sides have access to the same playbook. When one side starts hiding pages, it's not a fair contest anymore. Rather, it's just a rigged game. And I mean, I think that sums up what happened here. There is a extremely late, even you could consider it not even being provided because of when it is provided, turning over of documents which could have had important investigative purposes affiliated with them had they been turned over timely. And I think here it rises to a Brady violation because of the inability to investigate and therefore defend against the charges for which Mr. Garcia was on trial. Beyond that, again, we would ask the court to find that this was a Brady violation and remand to the trial court for a new trial.
Very good. Thank you both very much. This case will be submitted.
Thank you, Your Honors. Have a good day.
Thank you. You too.
Item number 6, calling People versus Roger Lewis Bailey, case number 374855. I believe we've received word that the prosecutors waived argument. So it's just up to you, Mr. Farrell.
I'm going to be very brief in my argument. I intend to be. Whether, Mr. Bailey was guilty or innocent or not, that's not part of this appeal. He pled no contest, whether he behaved admirably or not. That's not part of this appeal. He didn't behave admirably. He didn't behave the way we expect people to behave. The issue before the court's a very narrow one, whether OV8 was scored correctly. And I don't believe there's really any dispute between brother counsel and I regarding the facts of the case. You have the police report, you've got the arrows in it, and I'm arguing that they show nobody was inside the home at the time. I don't think there's a dispute about that. I think opposing counsel's argument is that People v. Barrera requires or should direct this court to affirm the scoring. And so briefly on that, People v. Barrera involved, and I know Judge Murray was on Barrera, and I went back and looked, and I can't tell from Barrera, the Michigan Supreme Court opinion or the Court of Appeals opinion, whether there was anybody else inside the home at the time. And the case goes back some years, so it's unfair to, but I don't see anything from the opinions that indicate, I had read Barrera as indicating there were people in the home, but in all honesty, it doesn't say that. What we do know about Barrera is that it involved a man who took his victim, a child, and moved her from a living room to his bedroom. Now, the living room of a home, very public area of a home. Defendant's bedroom, not a public area. If someone had knocked on that door while this was going on in Barrera, defendant Barrera would have said, go away, and the person probably would have gone away. So that, that's on its face, clearly movement from one place to a place of greater danger, his bedroom. I don't think we have that in the facts of this case. I think something more is required. We've got a movement from a home in which nobody was present. Mr. Bailey knew his wife's work schedule. He knew nobody was going to be present, to the, as I read it, outside of a garage. I think more is required, particularly where, she's a minor. OB states that the reason they were outside the garage was that's how he was bribing her into silence. That was the reason for going out to the garage. On top of that, Barrera, as I read it, the holding in Barrera has nothing to do with anything that's in front of this court. The holding in Barrera was regarding whether the incidental movement exception that applied to kidnapping also applied to OV8, and the court, I think both courts, Court of Appeals and certainly the Michigan Supreme Court, said that it doesn't. But that's not an issue in this appeal. We're not arguing anything about an incidental movement. In fact, what Barrera, the Michigan Supreme Court says in Barrera is that you don't look at that. You look at the plain language of the statute and whether it was movement from one place to a place of greater danger. That's the issue in this appeal. Is the outside of the garage a place of greater danger than the inside of the home when nobody was inside the home at the time? And I think if there was some additional fact, but based on the facts of this case, I think that it's not sufficient, and we would ask the court to remand for a resentencing. Unless the court has any questions, thank you.
Thank you very much.
Thank you.
This case will be submitted. All right. And that brings us to item number 7, Animal Partisan versus University of Michigan Board of Regents, docket number 374669.
Good morning.
Good morning.
Before I begin, I just want to say that this is my first appellate argument, so if I stumble over my words at any point, I apologize. Emily Bowden-Torres, representing the plaintiff appellant, Animal Partisan. May it please the court. Your Honors, this case is about the limits. Oh, I forgot to reserve 5 minutes for rebuttal.
That's fine. We'll ask you to keep track of your own time.
Okay. Your Honors, this case is about the limits of a public university's ability to withhold information it should disclose under Michigan's Freedom of Information Act. The trial court allowed the university here to rely on the Confidential Research and Investment Information Act's temporary intellectual property exemption, despite the information contained in the records to have been published by the university in an article in 2019. As my client has repeatedly clarified, it is not seeking underlying data from these video recordings. It is only looking for recordings of the mice's movements in water as described in the study. Under FOIA, the university bears the burden to show that the exemption here applies. The university has failed to do so. The university presented scant evidence, and the trial court should have required more context and more information to make a particularized finding before granting the motion for summary disposition in the university's favor.
And I'd like to begin with the intellectual property exemption and go right to the Louisiana case. That's PETA versus LSU. And as you're aware, the Supreme Court decided that as litigation was going on last year. The university is who initially brought this case to the court's attention. And there are some confusing facts in the case. There were 8 records requests at issue. The 8th records request is what's specifically relevant to our case here. But that case actually unequivocally supports Animal Partisan's position, and that's for 3 specific reasons. So in that case, the researcher, Dr. Latin, listed out there were hundreds of separate videos there. Here, we don't know. The university has referred to them as a set of videos, but otherwise we don't know how many there are. In that case, the researcher had hundreds of videos, and she specifically laid out which videos she had not reviewed and analyzed for any kind of output. About maybe 180 she had reviewed to prepare for some presentations to colleagues at conferences, things like that, and to publish an article. And the Louisiana Supreme Court there found that because she had used and analyzed those in preparation for those outputs, even though she had not included screenshots or posted the videos online or even showed the videos during those presentations, that they had, for the purposes of the statutory exemption, they had been, quote, publicly released, published, or patented, which is the Louisiana statute. And so here, the videos have undoubtedly been reviewed and analyzed prior to the publication of the 2019 article. And if there are certain video records that are separate that are distinct and were not reviewed for in relation to the study, those aren't relevant here. My client specifically asked only for video recordings related to that study and the published article. The second way in which the LSU case supports Animal Partisan's case is this idea of ongoing research. There, the LSU said, well, the researchers are still using these videos. It's part of an ongoing research project, and so they should still be exempt. And the Louisiana Supreme Court said, there's no exception specifically for ongoing research in the statute, and they didn't want to go beyond what was in the language. Sure.
Sorry, go ahead. Well, probably getting to the same thing. Isn't that where there's a distinction, is that in the Michigan statute, I think there is a recognition that the university should have a reasonable amount of time to do their research before and give them a chance to publish that in sort of the ordinary course before those records become public. And the record seems to indicate here that the university is saying, well, it's going to about 3 years is my recollection, and then that's the amount of time they were sort of thinking would be relevant. Whereas I don't think the Louisiana statute had a provision like that.
Correct. The Louisiana statute is actually broader, and there's no time element. It's just whether or not they're publicly released, published, or patented, and that could be 5 years, 10 years, 100 years. And yes, here it does. The legislature clearly wanted to give public universities the opportunity to publish, not feel rushed, have an opportunity, but they did add the clause in a timely manner to kind of then couch that within further reasonable grounds. And I would say that Professor Watson here has said that he may review the videos again, and we don't have much information about the potential future research, but what he has said is that he would review them, compare them to future data, and analyze from that comparison. And my client would argue that, first of all, this seems obvious, but I'll just say that even if the videos were disclosed, of course, those would be copies of the videos, and Professor Watson and his team would still have access to review those videos at a later date. But more importantly here, the this study, there's no evidence challenging that this study as a unit is complete. And once the article was published, the purpose of that study, which was specifically to look at ketamine's effect on unstressed mice as well as stressed mice, because it appears that the research prior had mostly focused just on stressed mice, that has been completed. And yes, the data may be reviewed again to compare to some other future currently non-existent data, but release of the videos would not hamper that. If a competitor researcher watched the videos right now, they wouldn't know what the future plans are, what the future data is that would be compared to then come to new conclusions. And so we would argue that the purpose of Korea's intellectual property exemption and providing that reasonable opportunity has been accomplished. And so we continue to say that disclosure of the videos would not contravene the purpose of Korea. And again, it's important to remember, you know, the underlying FOIA here, and it's undisputedly a pro-disclosure statute. And so we believe that there's a harmonization going on, and we're not trying to undermine Korea. And I just,
But
sure.
to Judge Crockett's question, you do agree that the statute in this state is different on this issue, this exact point than it is in Louisiana.
Yes, absolutely.
So then why is this Louisiana Supreme Court so helpful?
It's helpful in terms of what it means to be published and what use of the videos constitutes the protection for currently unpublished material when that ends. And so at the trial court, in discussion of, well, you know, the videos haven't been posted online. The screenshots, as Dr. Watson says, has never been published in the article, things like that. So it's sort of a delineation of what does it mean to be published, and you know, what are we talking about in terms of publication? And so it's
I guess the question that comes to mind for me is if you collect some data for two purposes, you plan to issue two research papers about the data that you publish. If what you're advocating for is the rule, that would really incentivize the university to not publish the first paper. Because as soon as they publish the first paper, everything's gone, and they've lost the advantage of being able to publish the second paper later on. So they're gonna withhold important research so that they don't have to publish, you know, they don't have to publish the data, and then that kind of undermines, I think, the purpose. So I mean, I think we'd be in a different situation if Dr. Watson had said, I have no idea what I'm going to use the data for now, but I'm done with the primary purpose. But the affidavit seems to indicate that he's got another research project going on right now, and he's asking for, or the university is asking for, a few years to sort of complete that.
Well, I would clarify that I believe Professor Watson never said that the research is ongoing currently, that he may use the data, he might need it for at least 3 more years, and he plans to correlate it with other future data. And again, I still think it comes back to disclosure of the videos now would not allow anyone to get a jump start in a different hypothetical where Professor Watson had said, I'm just going to analyze the data from these videos for some other purpose, for some other hypothesis, to test another hypothesis and come to different conclusions and publish a study. That's different, but we don't have sufficient information. I would again say that this goes back to the trial court not requiring much more information from the university. And of course, it's in the university's interest not to disclose these videos. The professor, you know, has reasons not to want to. So, and there's no indication that these plans existed at the time of the FOIA request, which, you know, is a bit suspect. And so I think it just comes back to, we want more information to figure out where the line is, because something that I wanted to mention is that according to the university's website, their retention policy is 7 years. So hypothetically, if they continue to say we're going to use it for a few more years, then the records could be gone and the public can have no access. So I think there has to be a balance of, you know, the university's interest versus their obligation to the public in disclosing. And having more information then would only allow the court to make a better decision whether it would harm the university to release these videos if we had more details about the future plans. But I would still argue that they have not said how disclosure of the videos now would hurt that future research. And that those pieces are already published in a freely, widely accessible study online. The pieces, I mean, shown in the video, and they've not articulated what is in the videos that is not in the study. So
I thought there had been no images from the videos that had been.
correct. But the level of detail within the study, including the size of the cylinder, the amount of water, when the animals received ketamine, how much ketamine, the manufacturer of the specific ketamine that was used, the schedule, I believe they were on a 12 hours dark, 12-hour light schedule in the room. And it went so far as to say 600 lux was the level of light used. So all of those details, and there are more, there's an abbreviated list on page 25 of my brief. All of those details serve to, if a competitor researcher wanted to create the experiment, of course, they would be using different individual mice. And so maybe mice 1 wouldn't move to the left at 30 seconds, but the heart of the study is already published, the heart of the information. And perhaps there is something that our non-scientist brains cannot think of that would still be discernible from the videos that has value. But the university has not articulated that. I think it would be easy to articulate that, but Professor Watson has not. So that's what I would say. And any other questions on that piece there? Okay, so moving on to the trade secret and proprietary information exemption, which of course the trial court did not decide because they relied on the intellectual property exemption, but also at oral argument, the judge clearly did not buy this argument quite as much. And the university does point out that in our brief first, we addressed just trade secrets and neglected other proprietary information. We've reviewed those cases that the university has brought, and I would say that they're in the same world of things. Trade secrets and proprietary information, yes, trade secrets is explicitly defined in Korea and other proprietary information is not. But in looking at the cases, both the MCOA cases and other trade secret cases, they're treated as really sort of the same set of items. And we went through in the brief, so I don't want to repeat it too much here, but the videos do not meet the trade secrets definition, perhaps most importantly because of the secrecy guarding element. The videos are known only to Professor Watson's team as far as we know, but I will mention again that Professor Watson could not articulate the precise number of people who have access to the videos or who have had access in the past. Which is strange. And
my understanding, and we'll obviously ask opposing counsel too, but my understanding of this trade secrets, proprietary information argument is that the research, that the forced swim test videos are going to be used, hopefully, to create some sort of other test that's superior to the forced swim test videos. And then it's that other test that's going to be proprietary and will have commercial.
Professor Watson did say, Your Honor, that the future research may have potential
I didn't take
commercial
them to be
values.
saying that the current forced swim test is proprietary, but that they're trying to get something that's better than that, which will be proprietary, and it's the current data that they're going to use to get that, and so they don't want to disclose it.
Your Honor, I'm not clear explicitly if that's the only argument. I believe they've also argued that these videos constitute trade secrets and should not be disclosed for that reason. And I'll just quickly point out that the other trade secret cases pointed to by the university, all of those involved confidentiality agreements, and we have no evidence of that here. And as to competitive advantage, which is, along the lines of what we've been talking about, the videos, if they ever did hold competitive advantage, we would argue do not anymore because the study has been published and all of the, key underlying information has been published in that article. And to the larger trade secrets or other proprietary information discussion, those cases seem to be focused on independent economic value. And again, we would argue these videos do not hold independent economic value. The study, the experiments could have occurred without these video recordings happening. Somebody could have, recorded in a notebook or something like that. This isn't, a feature film where the videos are the end goal. This is what it's all working towards. These are just a visual manifestation of what occurred. And I'd like to quickly address the Coca-Cola analogy brought up by the university several times. There they said that we're suggesting that if a person buys a can of Coke, then they're owed the secret formula for Coca-Cola. I don't believe that's a good analogy. It's more as though it's more similar to if Coca-Cola published the formula. But more realistically, a person who buys a can of Coke can see the ingredient list. They can know that it fizzles and the color and the taste, things like that. But you can't then, most people could not reverse engineer and figure out the formula. If you have the published 2019 study in front of you and you have all of those details, the manufacturer of the bedding that they use for the animals, how they classify different things, all of these elements, you can recreate the heart of the experiment. And so again, the university, it's their job to say what is left there in these videos that a competitor researcher could get an edge on them, but that doesn't seem apparent right now. Any other specific issues you'd like me to address? Okay, just very quickly, our affiants, their affidavits are admissible as they are experts, and they do not need personal knowledge as the university asserts because of Michigan Rule of Evidence 602. Just wanted to put that in there. Thank you.
I'll have some rebuttal time. Thanks.
Good morning, Your Honors. May it please the court, Brian Schwartz on behalf of defendant Appellee Board of Regents of the University of Michigan. The research data that plaintiff seeks here are the videos. Look, the videos are data to the researchers. The videos record, they show the mice. They're not just like a video unlabeled. These are videos that are designed to actually record the various data. It's akin to taking notes. It's not much different to it. 50 years ago, you might not have recorded videos. Nowadays, it's probably a little bit more common for researchers to do so. So we believe that the research data depicted in these videos is exempt under the exemptions that counsel was just discussing. And I just before turning to those arguments, the purpose of CREA here is to protect from disclosure research-related materials at the universities. It's focused on universities and this preliminary research. It's specifically focused to protect that, and it reflects this limited situation in a separate statute where the legislature had said, yes, FOIA is pro-disclosure, but we have a problem here. We need to address the problem. We need to make sure that universities research data just does not get out of hand willy-nilly. Focusing first on the intellectual property exemption. Here, I don't think there's any dispute that these videos were created by someone at the university and it constitutes original data. The focus is really on the length of time. Appellant argues that a reasonable opportunity has passed and therefore the exemption is not available. I don't believe that's supported by the statutory text because they're trying to engraft a portion of that LSU opinion on here. There is no bright line rule in this test, in this case. I think appellant notices or acknowledges in their brief that the statute does provide some flexibility. It's some cases, a reasonable opportunity might be a couple months, it might be a couple years. For some, it could be a couple decades. Here we have some evidence about the only admissible evidence is Dr. Watson's, affidavit about how much longer he thinks he's going to need. I do not believe that the Court of Claims ruling here grants any blanket discretion. Researchers can't come in here and say forever. Court would probably shoot that down. And the Court of Claims sit here is make a determination that based on the evidence presented that a reasonable opportunity has not passed.
So you'd agree though that it's your burden to prove what a reasonable opportunity would be?
It's our burden to, with all the FOIA exemptions, the
Prove
university
the
has to-
exemption,
yeah.
right? And so why wouldn't either Dr. Watson or some other representative of the university be subject to discovery, cross-examination, that kind of thing on that issue?
I think as with any litigant who's either side could be subject to discovery, and there's mechanisms for doing so here. You know, we filed a motion, counsel filed a cross motion. If in response to our motion, they could have filed an affidavit under 2.116, I believe, H, saying, here's the evidence I need. And it could have been what appears in the appellate brief. Here's what, in the appellate brief, they say, here's what what the discovery I wanted. Problem is, there's a court rule for a reason, because then we wouldn't have, wouldn't have had our oral argument. We would have probably been in discovery, and maybe we would have been briefing the appeal at this moment. So I think there was an opportunity to do so. The plaintiff also, or appellant also
And
focused.
can I just, one more thing on this point. Your opposing counsel raised the point. The affidavit is a little bit, it fudges a little bit, and I don't mean that in a pejorative way. It's not super clear on whether at the time this FOIA request was made, this data, this second set of experiments was being planned. And it does seem like if the university sort of came up with this after the FOIA request was made, that could be problematic. And so I guess I welcome your thoughts on whether the evidence is clear enough that the university's was planning on this at the time that the FOIA request was made.
I think it is, because what happens when the university gets the FOIA request in a situation like this, they go to the person who might have the records and say, and the FOIA office asks kind of questions about the records to find out what's there. And at that point, you have to ask the question about what's going on, and then it's denied on that basis. Obviously, there is no requirement to provide an affidavit at the denial stage, and nor would or provide evidence in the denial letter saying, yep, 3 weeks ago, I wrote down a note saying I was going to continue to do research. I don't think there's any counter evidence that this was just made up for the purposes of supporting the exemption, because it's a lot easier to just give up data if you're not using it anymore than to spend a couple of years litigating over data that's stale. So I don't think there's anything in the record to support that this is, self-serving in any way more than any other litigant is going to provide testimony that supports their own case. Turning to the publication of the article and the LSU case, I think one of the things that also might get missed from time to time is LSU, the statute there is kind of like a one and done. Once it gets published, it's out. And I think in that case, there was no dispute that some stuff was published. I know it's that the opinions aren't very clear on like, whether videos were actually shown or not, but they weren't arguing over whether it was published. It was almost like LSU conceded that they were published. So there you have a one and done. As Judge Schwartzel noted, nothing in the statute supports kind of the one and done experience. And so I think here, I don't think there's any evidence that these videos have been published at all. They are described, like the research is described, but that's what you're going to do. You can't go and recreate these actual videos. The reason they weren't attached is because they were, screenshots, some professors do that, is because they were considered confidential and they were still being used. I don't think, the assertion that the article contains hyper-specific details. I don't think yes, there are details in there. It's, if you look at it, I was looking at it this morning, there are summaries of the data in there, but you can't go and then say, well, here's what mouse 1 did. Here's what mouse 2 did. You can't recreate that. It's what you're doing in a 5 or 6 page article is you're summarizing, thousands of hours or hundreds of hours worth of research. So I don't think a summary of the experience conducted does mean that the raw details. But even if the court were to conclude that some of them have been published, which I don't think it can, I think exemption continues to apply because a reasonable opportunity to publish has not expired. Turning to the trade secret or other proprietary exemption, and I kind of noted, I believe the first time the other proprietary, the portion of the exemption for other proprietary information in which a public university or college holds an interest was addressed is an argument here. I don't think it was appropriately responded to or addressed in our reply, or in appellant's reply brief. And a lot of the arguments about why the trade secret exemption doesn't apply don't really apply to the other proprietary exemption. Those kind of elements about, used in the business, competitive advantage, sufficient measures to take to guard the secrecy of the information, all those elements come from the definition of trade secret. And other proprietary information is kind of a different mode of analysis. So we believe that the university has a proprietary interest here in the data. That sub-exemption applies, but we also believe it's a trade secret.
What's the proprietary interest in the, and maybe this is just because of the record was kind of slim, but my understanding is that Dr. Watson was saying that they were going to come up with, they were hoping to come up with a better test than the forced swim test. And if they were successful with that, that would have commercial value. And so that would seem to me that means that the hoped for product in the future would be proprietary, but that doesn't seem to suggest that the forced swim test, which is something that, according to their experts, like is kind of a dime a dozen, is proprietary.
Correct. It's not I don't think the issue about the forced swims test itself is common, used all over the country. Apparently, I didn't know that before this case, but it gets used quite commonly. I don't think the issue is with the forced swim test. It's these specific iterations of the forced swim test. And in Dr. Watson's affidavit in paragraph 10, which is in appellant's appendix on page 41, that's where he describes, and it's not, he wasn't wishy-washy. He says, I might still use it. He actually says the data from those experiments is still being analyzed. And then he says specifically, and he goes on to describe that potential commercial application. But that potential
But if that's proprietary, then all data is going to be proprietary. And then the university just asserts this exemption for all data till the end of time.
Well, it's for, that's what the clear statutory text. I think the design here is to protect the research and not, otherwise you wouldn't have, so there are two aspects I was going to get in. So it could have commercial application, which I believe is different than proprietary. The university is a large research institution. It's in the business of conducting research. So the maintaining a confidentiality of its data is important. If you can come in and get any university researcher's data,
It's not forever.
yeah, it's not forever. People move on. It's not being used. The university is not always going to fight. They don't just deny stuff just to get into FOIA lawsuits. But when there's ongoing research going on in this situation, I believe that it is proprietary. So that's if Judge Schwartzel had, not in his opinion, but during oral argument, he questioned whether the university was in a kind of the business. It's not in a business, and I think he was thinking in a kind of the for-profit sense. True, could what Dr. Watson is planning to do have commercial application? Yes, and that could support the trade secret. But I think you don't need to have a moneymaker to have it be other proprietary information. And I think that's how the statute was written, to support kind of protecting some of this research data.
Doesn't that just swallow the reasonable opportunity exemption? Why would you need a reasonable opportunity exemption if all of the data is always proprietary?
Well, I don't think it necessarily, because there could be stuff that's that might not be, I guess, proprietary in theory. You'd still have to prove that there is a proprietary interest there, but there are alternative, exemptions that exist here. I mean, you could always argue anything that's a trade secret might be intellectual property, but there are alternative mechanisms for kind of exempting the data. And I think the fact that there are 4 separate ones indicates that the legislature was concerned about making sure it kind of covered a couple different loopholes for people to get the data. It wasn't just, a short, simple one like you see in LSU, and I think Ohio has the similar one where it's a little less protective. The legislature here, I think, was pretty protective and seems to be one of the more protective ones I've seen in some of these research cases that come up with public disclosure records. Just turning kind of briefly to the other aspects of, the aspects of use in the business, efforts to maintain secrecy and not, readily ascertainable to competitors. I believe those all focus on trade secrets, not the other proprietary information aspect. But on the secrets, I think there is sufficient information in the affidavit to suggest, to prove that there have been reasonable efforts to maintain secrecy. It's, that the statute itself doesn't require, the trade secret definition doesn't require Fort Knox-like procedures. There are a finite number of people in a lab that have access to this. If he had just said, the 11 people in my lab, and I don't know how many people, that seemingly would cure the problem, but it's clear that there's not an open-ended, I can't walk in there and just, I guess I'm not the right thing, but someone from the public can't just walk in there and get access to this, and there's nothing to kind of undermine that. I kind of addressed the readily ascertainable aspect of it a little bit, but just to touch briefly on kind of where they say their affidavits are demonstrate it's readily ascertainable. I don't think any of their affidavits support that. I also don't think they're appropriately, appellants seem to kind of back off that these are appropriate, lay witness affidavits. They say now they're experts. I don't think a sufficient preliminary showing has been made to show that they're either qualified to opine on whether forced swim tests, what's in the forced swim test video, and none of them have even attested to ever doing the forced swim test video. I also don't think there's kind of any sufficient foundational to support the 4 elements of Rule 703. For that reason, we would, unless the court has any other questions, we'd request that the court affirm.
Thank you.
Just to first address the opposing counsel's last argument about the information being readily ascertainable and that our affiants never challenged that. Our affiants did say that they did not believe there was anything that would be discernible from the videos that was not discernible from the published study. And to go back to the expertise of the affiants, I believe the university has repeatedly said that because they don't have the same expertise area as Professor Watson, somehow they, are not experts or they don't have the right set of expertise to provide guidance here. Dr. Fargali does much of his work around the use of forced swim tests in depression research, which is what we're discussing here. Even if he has not engaged in a forced swim test before, which I'm not 100% sure if he has or hasn't. It is still an area of expertise for him. And Dr. Lavis, his specialty is neuroscience, which is very related to here, I believe, Professor Watson's specific expertise is the neurobiology of psychiatric disease. So those are very related. And Dr. Lavis has worked extensively with mice and research for many years and is familiar with working in a university and publication timelines and things like that. Then to go back to, I believe when you asked Judge Kropkin about the proprietary interests in the data, opposing counsel's response was that it's a large university and confidentiality is important. First, I'd like to again remind the court that we have no evidence that confidentiality agreements were signed, which seems pretty common in these other cases. And there was a Virginia case that the university pointed to, American Tradition Institute, in the briefs. And there, one of the many proprietary interests that the court found led to the exemption being applied was that the data there included many email communications between the professor and outside sources, professors at other universities and other contacts. And so confidentiality there was very much at issue, and they found that release of the communications would impact the university's ability to work with other universities and, professors to work with other professors and things like that. So I would say that's not the case here. And early on, opposing counsel mentioned that the university believes the videos aren't data. And I just want to quickly read in the study itself. This is how the videos are described. Quote, during the test, movement of the animals was tracked with the camera system, parentheses, mounted horizontally and facing the sides of the two tanks. And that's at A45 of our appendix. So I would challenge, the line there of what's data, what's not. Again, that quote from the study seems to suggest that the videos only captured the mice moving in water, not researchers or assistants or any other kinds of data, the ketamine, how much they were given, which is important. Those are published in the article. So even if they are in the video recordings, they could either be redacted or they're already, published. So that isn't important to sort of keep secret. I would say to the university's argument that there's no slippery slope. Of course, if a university came and said, we're going to use this for 100 more years, perhaps, a court would ask more information. I think here it gets down to the trial court did not ask for more information, nor did they undertake in-camera review, which could have answered most or many of these issues that are ongoing here. And that, points back to cases I cited in the brief evening news from the 80s, where, this inherent imbalance was acknowledged by the Supreme Court, and they pointed to in-camera review as a way to address the inherent imbalance in FOIA cases. And then the King case 30 years later, reanalyzing, reaffirming, there is this imbalance, and in-camera review is a way to make a particularized finding. And that is missing here, I would argue.
Well, Counsel, I know you'd asked for 5 minutes.
Oh, sorry.
We've had that, but if there's anything else before you want to wrap up.
Just reminding the court that the burden is on the university, that FOIA is undisputably a pro-disclosure statute, and that or what we're asking for here does not contravene the purposes of CREA. Thank you.
Thanks very much. That case will be submitted, well briefed and argued. I think, should we take a break? Yeah, we're going to take a break and come back for the rest of the docket.
Court of Appeals State Mission now in session. Please proceed.
All right. Thank you for your patience, everyone. We'll move on to the 11 o'clock docket. And just a reminder for anyone who wasn't here before, if you're in a case involving children or victims or other vulnerable individuals, please use their initials rather than their names. And with that, we will call item number 8 this morning, which is it's 3 cases consolidated: 369025, 369026, 369027. Jennifer Jansen Rogers versus Department of Environment, Great Lakes and Energy, Doretha Brazil versus Department of Environment, Great Lakes and Energy, and Oliver Kavanaugh versus Department of Environment, Great Lakes and Energy. We're just going to have one argument for all 3 of these together. So we'll start with the appellants, which are from Eagle.
Morning, Your Honor. Your Honors, Nathan Gamble, Assistant Attorney General, here on behalf of the defendants. May it please the court. The fundamental error that the lower court made was to treat the defendant's motion as if it was filed under C8 and to give equal weight to the plaintiff's allegations as it did to the defendant's evidence. But in reality, the defendants moved under C7. And under the C7 standard, when evidence contradicts allegations, the contradicted allegations are disregarded by the court. And that's not what the lower court did. Instead, the lower court held in its opinion that the lower court acknowledged, yes, the defendants have brought all this evidence that contradicts the plaintiff's allegations, And in his ruling, he just said that means there's a genuine issue of material fact here for trial. That would have been true if it were a C8 motion, but it was not. It was a C7 motion. So what the court should have done was disregarded the allegations that were contradicted by the defendant's evidence, and then determine if there was a genuine issue of material fact about whether the plaintiff's lawsuit was timely and or not. And he didn't do that. And so the lower court misapplied the standard here. And so what the defendants have asked this court to do is to simply apply the correct standard. And if this court does that, it disregards the allegations from the plaintiffs that are contradicted by the evidence. And ultimately, that will show that the plaintiff's lawsuit is untimely. So under the Court of Claims Act, in order to file suit, the plaintiffs had to have committed in their complaint when their claim accrued. That's a statutory requirement. It's 6431 sub 2 sub A. It's required that the plaintiffs say, this is when our claim accrued. And they actually do that here, Your Honors. In their complaint, the plaintiffs say that they began to be injured by lead in their water, both their persons and their property, beginning in January 2018. And they wish to represent a class of people in Benton Harbor who were injured just like they were all the way back to 2018. But the plaintiff's problem is that they didn't file this lawsuit until, well, two of the plaintiffs filed in December 2021, and then the rest of the plaintiffs was April 2022, so several years later. So their claims accrued more than 6 months before they filed the lawsuit, so the claims are untimely. It really is that straightforward in this case. But the plaintiffs say, well, the defendants fraudulently concealed our claims from us, and they raise a variety of allegations that are contradicted by the actual evidence, which is why we have focused so carefully on the correct standard that should be applied here. Because evaluating the actual evidence shows that the defendants didn't conceal anything from the plaintiffs. In fact, under the law, when there's an action level exceedance for lead, the defendants ensured that the local government made it a matter of widespread public knowledge that there was lead problems, that there was potential for excessive lead in the water. That was announced. There was press conferences, news coverage for months and then years as Benton Harbor continued to have action level exceedances for lead. This was very widespread public knowledge. And again, the lower court said, I see all that.
But they didn't say it wasn't drinkable. They said there's more lead than the government allows, but you can mitigate it by X, Y, and Z.
Yes, that is the standard messaging for an action level exceedance for lead, because when there's an ALE for lead, it does not mean that all the water in a particular water system is completely undrinkable. That's just not what it means. And so there's over 200 action level exceedances for lead in 1 year alone in this region of the country. And within Michigan itself, during the time that Benton Harbor had this action level exceedance for lead, there were over 60 action level exceedances within just the state of Michigan. And it's not correct, and it's not what the law requires for the local water supplier to thereby advise everyone in all 60 of those systems, don't drink your water. Under any circumstance, it's poison, which is what the plaintiffs think. That's just not true. It's not what the EPA requires. It's not what Michigan law requires. It's not accurate. And so,
The argument about the trial court applying the wrong standard, summary disposition standard, is that mostly with respect to the fraudulent concealment issue?
yes, I think so, Your Honor. Yeah, because the face of the pleading itself says this is when our claims accrued, January 2018. And so really, I think that the lower court's emphasis on this conflict between allegations and evidence was about the fraudulent concealment, because that's the only exception that they've relied on. They've already said, we're not relying on the discovery rule. We're not relying on continuing wrongs. We're only relying on fraudulent concealment.
But if you have a bodily integrity claim, which requires a shocks the conscience analysis, does it really, I mean, as I understand it, there's some there's an unknown about when does the government conduct rise to the level of shocking the conscience? And it may not be on the date that the lead was discovered or announced or so forth. And that that's kind of that might be a question of fact that that isn't susceptible to your C7 analysis.
I mean, that kind of goes right back to what you said, which is there's some lead that even when you issue a warning about it, it's still drinkable. You're still, so, I mean, you just kind of acknowledge that all of these emergencies aren't the same.
Yes, and to try and answer both of those questions, Your Honor, in terms of when the claim accrues, we take the cues from the plaintiff's complaint. And so what their allegation is that as soon as there was an action level exceedance for lead, the government was required to tell everyone the water was poisoned, don't drink it no matter what, under any circumstance. That's the theory. And so based on their allegations, that arose in 2018. So that shocked the conscience. And that's why it kind of addresses Judge Greenleaf Maldonado, your question about what these notices contain. What they do is they advise people how to mitigate the risk, lower the risk, and immediately Eagle and DHHS started meeting with the local government to help them understand this is what you do when you have an action level exceedance for lead. They made water filters available. It's usually not for free, but in Benton Harbor, they made them available for free for anyone who wanted them.
Eventually.
Yes, by January 2019, when the local government that said they were going to didn't, the state stepped in and funded it.
So the initial notices that went out, is it your contention that they provided good and accurate advice to the public?
Yes.
Okay.
Yes. And
because I thought that advice was actually the standard language was geared towards lead pipes that were in a house versus at the water, in the water coming into the house. I thought there's like a difference between the kind of notice that you're supposed to provide. Am I incorrect? I could be wrong. Correct me if I'm mixing. There's a lot of information here.
It could be, Your Honor, that you're thinking of, because the way that the local governments test for lead is they test a sample set. They don't test all 10,000 water users. They test, maybe 100 or something. I'm sorry, I don't know the exact number here, but they test 100 or something. And if you're maybe of the 10 people who are confirmed, oh, it looks like you have excessive lead in your drinking water, the outreach to those 10 people might be different than the citywide notice that they then issue to everybody on the entire water system. But the reason that I keep going back to why these notices are accurate is because the way these tests work is they're not meant to detect, they're not meant to be activated only if everyone has lead in their water. So it could be that you test 100 people, 80 of them have zero lead. So most of the water is zero lead at all. But because of the way the tests are worked, they're geared towards public health and safety. So it has a pretty low threshold. So if there's even a small number of people who do have excessive lead, they just say, all right, everybody in the whole water system, there's a risk here for you. Even though 80% of these tests have zero, you've still exceeded the action level exceedance. And so we're going to warn you, here are ways to mitigate this risk in Benton Harbor. Here are these water filters. And I think one of the facts that occurred in 2021 that bears discussing is that in September 2021, so this is 2 years, about 2 years later, a collection of local groups and national groups essentially sent a complaint to the EPA saying, we don't think that these water filters are working. So we get that they've been available. We don't think they're working, and we want bottled water. And so the governor, Eagle, and DHHS responded and said, okay, what we'll do is we'll provide bottled water. And in the meantime, we'll have EPA do a new round of tests on these filters to confirm. And so between September 2021 and It was March 2022 that the EPA confirmed, yes, the wilt filters are effective, but in those maybe 5 months or so, 6 months, that's when Eagle and DHHS said, look, we've had complaints about these water filters, and so we're going to do these tests. In the meantime, we're providing the bottled water that petition asked for. So everyone can have bottled water as well at no cost.
Right, but that was around the same time that this exchange, which I understand is a little controversial, with Andy Levitt took place. And in that exchange, it looks like Levitt is telling Eagle, or maybe it's the governor's office, I'm not sure, but Levitt is saying, look, you guys aren't being straight. You need to tell people that they need to stop drinking the water. Now, I'm not taking a position on that, but that could be the moment, couldn't it, when the state's conduct rose to the level of shocking the conscience. I mean, we have this sort of strange situation here where if the government's allegedly unconstitutional conduct occurred earlier, if they were engaged in lots of unconstitutional conduct, then the claim accrued earlier, and then you have more of a potential for a limitations claim. But if here the government was actually doing what it was supposed to be doing up until a certain point, and then things went wrong, you have a later accrual date. And so why isn't that a potential question of fact that requires us to sort of keep things moving forward?
Well, again, the accrual analysis focuses on the plaintiff's complaint. That's what the Michigan Supreme Court has directed. And so we look to what they say violated their constitutional right. And what they say was that back in 2018, that's when their rights were violated. And then if there were any doubt about that, in their briefing below, they explicitly concede all the elements of our cause of action were present on these dates. And we brief it in great detail to say, well, look at these allegations that they're pointing to in their complaint, where they say the elements of our cause of action were present when the government took these actions. It wasn't Mr. Levitt's email to, I'm not even sure who he emailed. It certainly wasn't an Eagle consultant. He wasn't someone working for the government. It was just someone sending an email.
A lobbyist or something like that?
I think
Yeah.
so. He's an outside person. It's basically
Yeah.
a citizen letter to the government, So
But if your initial notice was accurate, then there was no harm at that moment in that point in time. Doesn't that kind of go towards their point that the harm that they're complaining about accrued later?
Well, no, that goes to our point, Your Honor, because that's a dispute about the merits of the claim. Our position is that was accurate. The government did nothing wrong by sending standard notification materials to the people in these water systems. The plaintiffs say, no, that violated our constitutional rights. We say, well, fine, that's when your claim accrues. So they have a different view about that notice, but that really just shows that they're alleging that's when their claim accrued back in 2018. And
Or they're setting the stage for how this developed, because, I mean, if they just jumped to like 2020, I don't know what the right date would be, but, a couple of years later and said, okay, and this date, I mean, it doesn't really set the stage.
I can appreciate the setting the stage idea. It's just not what they say. In their complaint, what they say is that their claims accrued back in 2018. And so the statute requires them to commit to a date, and that's the date they committed to.
Well, I thought Mays said that the statute doesn't really require the commitment to a particular date.
No, I don't think Mays held that as a general proposition. Mays was really an unusual case because it's so different from this situation, because in Mays, there was no action level exceedance for lead. So the test that came back in Flint said, nope, no action level exceedance. So there was no public materials that went out, no press conferences, there was no advisories sent out to anybody. And that's why this court, Michigan Court of Appeals in Mays, said, look, you at that time, government, said that you didn't even have a basis to believe there was excessive lead in the water because there was no action level exceedance in Mays. Here, it's totally different. There was an action level exceedance, so all this public messaging went out, and that's really goes to the fraudulent concealment kind of exception that the plaintiffs are really leaning on here. They're saying they hid this from us, and we're saying, how could that be possible?
Well, no, they're saying you hid how bad it was. Not that you hid the fact that there's lead in the water. I think they concede that you sent out these notices and there was lead in the water. It's just that it wasn't drinkable, is what they're saying.
Well, that is what they're saying, but what they're saying is that it was never drinkable starting in 2018. That's when their claims accrued.
Pulling it up.
And we're saying, well, fine, it's untimely. Now, and this really, I mean, this isn't a motion on the merits. We didn't file under C8. To be sure, we think there are major problems with the merits of the plaintiff's claims.
And the Sixth Circuit issued an opinion on that, didn't they?
They did. Yeah. And so the Sixth Circuit has ruled that our clients, there's no claim that these plaintiffs have against our clients.
No federal constitutional.
No
claim.
federal constitutional claim. That's correct. So, but that's really not the posture of this appeal. We're really focused on the timeliness here. And yeah. So, yeah, so the Mays as a general rule did not just exempt everybody from the requirement that the Court of Claims Act to commit to accrual date. It was really a fact-specific ruling under the unusual circumstances of that case, and it just doesn't apply here. It's a very different circumstance.
What do you do if the argument is made, it probably was made in Mays as well. If, I don't remember how many plaintiffs, individual plaintiffs are, but they want to be a class action, right?
Yes.
And, you know, with ingesting lead, you don't automatically become sick or, you know, necessarily suffer an injury. What do you make of the argument that, because you have to have all the elements in existence for your claim to accrue, if someone says, well, you know, they ingested it, but they haven't suffered any physical harm from it yet, so that their claim didn't accrue yet.
Well, that was the allegation in Mays. That is not the allegation here.
Not making that here?
No.
Okay.
Here, they alleged not just that they were exposed starting in 2018, but they were injured, both person and property.
Can you give me a citation? Because this is a consolidated case. There's a bunch of complaints.
Yes. There's a single consolidated complaint that was filed in December 2022 that includes all of the plaintiffs.
Okay.
And the citations, Your Honor, are in the brief, but I
Yeah,
have
if you-
several. I have several, so I'll just read them.
Thank you.
But if you look at paragraphs 28 through 37, 164 period E, 1, 29 through 36, which I think I already said that, 184, 194, 153, 158. And they're
Thank you. Appreciate it.
You're welcome. And what they're alleging is that they're an identical interest with people who have been injured since January 2028 because they want to be a class. And they're alleging they were injured. It wasn't like Mays. And so if we just take the cues from their complaint and from their arguments, the claims here are untimely. And the lower court should not have allowed this to proceed. And so unless the panel has any additional questions, I'll reserve the remainder of my time for rebuttal. Thank you.
So Ms. Martin, I just wanted to confirm you'll be arguing for all of the plaintiffs, right?
Yes, Your Honor.
Okay.
Good morning, Your Honors. Annika Martin, Leif Cabraser, Hyman, and Bernstein, on behalf of the appellees for all of the consolidated complaints. May it please the court. So just to zoom out, there are constitutional rights at stake here. And our position is they should be considered on the merits and not dismissed on the technicality. Judge Shapiro below applied the C7 standard correctly. The C7 standard in part says that if factual development could provide a basis for recovery, dismissal without that factual development is inappropriate. That comes from Dextrom. Judge Shapiro did consider their evidence and our allegations and our evidence, because we also included evidence, and he considered all of it at face value. He did not weigh the evidence against each other. He considered at face value, which he's required to do. And contrary to what the appellants argue, you cannot just disregard allegations willy-nilly just because there is evidence. You need to disregard specific allegations that are specifically contradicted. That comes from Patterson. So examples of specifically contradicted, if you think about what's in the statute itself, if we allege, or if a plaintiff alleges, I never released this claim, and someone, the defendants then include a document that shows that there is a signed release, specifically contradicts that allegation, there's your whole case, done. In the context of this case, let's say we alleged on X date that the lead amount in the water was 50 parts per billion. They have a document that says on that date, it's 5 parts per billion. That allegation is specifically contradicted. Now, if we have a document that we include that says it's 50, now we have document versus document, so now we're at a factual dispute. But if it's just the allegation and they specifically contradict the allegation, that's when you disregard that specific allegation. It can't be something vague like we strive to do our best to protect the public health, and so we would never do something like that. It can't be a spin on the facts. So if we've talked about, here's an email to Great Lakes Environmental Law Center, and where they said that corrosion control is working, and then they have an affidavit, and the affidavit says, well, that's not really what we meant to say in that email. What we meant to say in that email was this, because this is what this means, and this is what this means, and we had internal discussions about how to just respond to that, and this is the decision we came to. That's not a specific contradiction of our allegation about that email. If you said that email is a fraud, it was never sent, here's the IT proof that that email has been tampered with, and here's the original, or something like that. Now you're saying that's a specific contradiction of that piece, that allegation. If the allegation about that email is, here's an example of fraudulent concealment because they knew, and this email is, showing that they knew and they hid it, an affidavit that says, that's not what that says, or we meant something else, or this is the discussion we had. That's not specifically contradicting our fraudulent concealment allegation that's based on that email or that quote. So you have to be really narrow and really specific to use this specifically contradicted tool to disregard an allegation, according to Patterson. None of the cases that they cite have examples where they're using this specifically contradicted to throw out huge swaths of allegations. One thing you can say in this case is that we all agree on is that there are lots and lots of facts, and we all agree that we disagree on the facts. And so, it's not the case that we can just throw out our allegations based on some evidence that they have. A great example that I can use, and Your Honor has already mentioned it, is what we call the Greek email. It's the email from Andrew Levitt. It is at page 952 in the record. And in the version that you guys have, you see it exactly as we saw it, which is the email from Andy Levitt begins with 2 lines of what look like Greek text. And then it goes on to talk about, the pamphlets and all that sort of stuff. The Greek text is actually not Greek. It is English words that are rendered in Greek letter font. Our allegation is that this is part of, and this is a great example of, the fraudulent concealment cover-up. Here is an email that is written in code, perhaps to avoid being found in word searches for FOIA requests. This email, in fact, was not produced in the FOIA requests production. It was discovered later and then had to be specifically requested and then was found. So this did not come out in the FOIA request. And the Greek text says, hot off the presses, as I warned, there are major red flags. It seems like we are back at square one, having not learned much from Flint. Andrew Levitt holds himself out as being a consultant for the government. The initial email that begins this chain is from Kara Cook, at the governor's office, sending something to Levitt. And then this is his response, where he talks about everything that he thinks are wrong with the pamphlets. These pamphlets are the notices that were sent out to the residents of Benton Harbor and had been sent out to them. This email's from September 29th, 2021. So now for 3 years, these folks have been getting these messages that, as Levitt says, over and over again, never say stop drinking the water. They say this, they
So
say
how
that.
does that impact the analysis? Because we have to put the merits aside, right? And just think about, well, how does this impact the merit, the analysis of when the claim accrued?
Sure. So as Your Honor said, the shocks the conscience standard has to be looked at holistically. In Mays, they talk about the difference between when you have split-second decisions that are being made and when you have time for reflection, you have time to change course. And that is a different scenario than if you're really just making decisions on the fly in an emergency short-term situation versus a long period of time. Here's a situation where we have a long period of time, multiple opportunities to course correct, multiple opportunities to tell people stop drinking the water, multiple opportunities to tell them corrosion control is not working, multiple opportunities to tell them filters are not going to help when your lead level is 889. Multiple opportunities to tell them you have to properly install your filter and use it, and here's how to do that, all of which they never did. So when you have a situation like that, then shocks the conscience is going to be a buildup over time, and at some point there's going to be a point where it's risen to the level of shocking the conscience.
What point is that?
Well, to know that, you have to have the full picture of the actions and inactions. So if you don't know, the full timeline and depth of the state's knowledge.
So you don't even know if your claim was ripe when you filed it. Is that what you're saying? I mean, because you're supposed to know, you're supposed to have all the elements, right, for the claim to accrue. And part of the elements are what you just talked about, the shocking the conscience. So when the complaints were filed in late 21 and early 22, had it occurred already?
So our position would be that, shocking the conscience, we look at an email like this. This is September of 2021. This is a situation where they're told really, really clearly, you have not said the right thing. You have not said the right thing. Yet they still didn't, September 29th, 2021, do an emergency press release and say, stop drinking the water. It was a month later.
So under that theory, that is the accrual date.
Well,
Thereabouts.
Without the full factual development, I can't tell you because I don't know the full timeline and depth of the defendant's knowledge. But
you want it to be later, right? For your position, the later the accrual date, the better.
Sure, for the accrual argument. I mean, we also have the fraudulent concealment argument, and this email again is a great example of that too. And we've made, allegations throughout our complaint with lots of examples of the fraudulent concealment over the course of the years. And our argument there is that it's not until October 21st when finally, under the questioning at the House Oversight Committee, it's let's talk like normal people here. Is the water safe to drink? No, it is not. They should not drink the water. Finally, October 21st, 2021. So from our perspective,
that's when they acknowledge it. That means, but before that is when the if it happened, the concealment occurred.
Right, certainly. So what I'm saying is October 21st, 2021 is for us the date that our clients, now finally know that this concealment has been happening. So that's when the 2 years begins on the fraudulent concealment tolling.
And that's consistent. I pulled up the consolidated complaint and on paragraph 29, you set the stage by talking about in the fall of 2018, but then you say later on, at no time prior to late October 2021 was plaintiff ever notified by any of the defendants or the city that anyone in the household should stop ingesting the water.
Correct. Exactly. And so that for the fraudulent concealment, that's our date for that.
Almost like I'm just trying to, figure this out in my head here. Because these are just unique cases, because typically with the Court of Claims Act and all these, you have a slip and fall or something where you know what happened, when it happened, and it's not very hard to figure out what the answer is in the case. And this is different. And it's almost like, I was just thinking like, even though typically the state does these motions on notice right away, it's almost like they should file a summary disposition on the merits to figure out, was there conscious shocking behavior? And if so, what was it? And then once that's figured out, then you can then say, okay, well, we'll apply that, what we've determined, if there's no genuine fact on it. And then you can figure out whether it's timely or not. You know what I mean? Because there's no, we're dealing with a loose set of facts and circumstances on a vague test, you know, shocking the conscience. It's just strange. It's kind of hard to box it in and figure out where it all falls.
I agree with you absolutely, Your Honor. And that's why this is different from a lot of the cases that we see under the C7 standard that are, here's a release, here's an agreement to arbitrate, something like that. This is different. This is a really complex set of facts, complicated by fraudulent concealment, complicated by that we don't have discovery, any discovery from the appellants. And so, you know, I mean, we have more than most people have when they file a complaint because of the FOIA request, but the FOIA stuff, as we know, because this email wasn't in it, you know, we know it's not complete. And
Let me ask you this
yeah.
question. Because you have the two claims, the bodily injury, bodily integrity, whatever we call it, and the inverse condemnation. And when, that's based on the lowering of the value of the real estate because lead is in the pipes and in the water. That pretty clearly occurred, and everybody knew about it in 2018, right? Lead levels higher than what the federal government permits was going into these certain homes, right? And they notified everybody about it. It was on news stations. So presumably anyone would say, well, I'm not buying a house there if lead's in there at a rate higher than it's supposed to be. Or if it is, I'm going to get a better deal on the property. I mean, so how is, I guess explain to me, because it seems to me that the inverse condemnation is a clearer damage and everything had accrued before 6 months after you filed the complaint or prior to filing the complaint, with the bodily integrity being different because you don't know when you're harmed and all that kind of stuff.
Sure. So absolutely,
Too long of a question.
No, I'm following. No one disputes that the first ALE was in 2018, and that was the first time that anyone knew that there was lead in the water. I don't know, maybe appellants knew something else earlier, but no one disputes that 2018 is sort of the date that, you know, everybody finds out publicly.
Notice, yeah.
Now, the question of, does that mean the property values start immediately decreasing? I don't know the answer to that. When do they start decreasing? Because this is also confounded by the fraudulent concealment. Because remember, right away, we're coming out and we're saying, it's okay. You've got filters.
Yeah, but
you can flush.
Right, but that's for ingesting it. But isn't the damage, the cause of the lower property values is not because I'm ingesting it. It's because, well, I guess it's part of that. And part of it is it's flowing into the house, into the system. And therefore, most people won't want to purchase that property because they don't want to deal with the problem. And that had been going on for years. Now, yes, it was disclosed in 21 that, yeah, you shouldn't drink it. But they'd already been told, don't use it for your babies. You know, and they had, like Judge Maldonado pointed out, all these other ways to reduce the threat of it. So to me, that damage, the harm to their property and the value went down when the ALEs came out and it was publicized all over the place. Because any other reasonable person is going to say, well, I'm not going to, like I said, that right there lowers. Now, when you say you can't drink it, it may lower the price even more, but the damage and the harm has occurred.
I see your point.
Yeah.
Our point is just that, you know, without further factual development, we can't know the date that they start decreasing. I think there's a way to know it or to have an expert do some crunching of data.
But I think what Judge Murray's saying is just common sense, that there's going to be some, might be minimal, but it might be some, I mean, there's some. So does that equal accrual?
It could. I just don't know exactly when it accrued, or exactly when that date was, and I can't know that without help. I mean, I agree, common sense, says that, but I don't know if that's the actual answer. I would need an expert to help me understand exactly when the prices started going down. I also don't know how much the fraudulent concealment comes into it, because if you are, you say, oh, well, don't they have lead in the water in that neighborhood? But then it says, oh, no, but the government's right on top of it and they are taking care of it. And in the interim, they're taking care of it. So this is just a temporary thing. They're working on it. They're doing all this corrosion control. They're fixing the pipes. Everything's going to be fine. They're just helping the residents with filters in the meantime.
Do you know what the law says about, because I don't right off the top of my head, so maybe you can direct me. But does it matter how much the home devalued? Because if it was de minimis, is that a different situation than if it was substantial?
I actually don't know the answers to that, Your Honor. I apologize.
The claim is against Eagle as opposed to the city. So the question is wrapped up with when Eagle did something
That's a good point.
culpable.
Yeah.
Yes, these claims are against Eagle and DHSS,
And
but
DHHS, yes.
yeah. Yes, we did also have claims against the city, and there's plenty of blame to go around in this crisis. And, part of the factual development is everybody's role here. Appellants have a lot of allegations about, things that were the city's fault versus their fault. And, that's great that they say that, but, we'd really like to see, the documents and the communications to really see who is taking what role and who is really signing off on this and approving this and making these decisions. And so
It seems like the later in time Eagle is to blame, the more likely your client's claims would be timely
for accrual, yes,
for accrual purposes.
that is right. Or the
Ironic because
later
the-
that it rose to is shocking the conscience.
Ironic because the longer the amount of time that Eagle was engaged allegedly in unconstitutional conduct would theoretically be worse for Eagle, and yet
That is
for
correct.
accrual purposes, the question is, well, when did it rise to the level either of shocking the conscience or of diminishing the values of the property?
Right. Correct. But, I think we've argued in our briefs, either way that you get there, whether it's fraudulent concealment or accrual, we're in a situation where, as they said in Dextrum, if factual development can provide a basis for recovery, dismissal without it is inappropriate. And our position is really, this is the sort of, poster case for that. And Mays was also a case that was much more complex facts than just a release or, a simple thing where you can very specifically contradict one specific load-bearing allegation and the whole case is gone. This is not that kind of a C7 case. And I think that they're arguing that it is. A couple of points that I just want to point out, we do not say, they gave us some cites in the complaint, and as they were talking, we were sort of just checking those at our table, and none of those say that we believe that our claims accrued in 2018. We have never argued that. We've never pled that. We say that the ALE was in 2018. We say that exposure began in 2018, but we never said our claims accrued on that date. And we've never argued that. We've never briefed that. We've never said that in the complaint.
So
yeah.
you think Mays is actually, they're saying Mays is different, that this is a very unique case. You think Mays is on point and helpful?
Yes, absolutely. Mays, there is this factual difference. Mays talks about or turns on a switch in the water source. But the crux of Mays is concealing the toxicity of the water. And that's even the language that they use in Mays, the toxicity of the water. They don't say concealing lead in the water. They say concealing the toxicity of the water. And it's the exact same thing that's happening here. They're concealing the toxicity of the water. Sure, they're saying left and right that there's lead in the water, but they're also saying we're doing corrosion control and it's working. It wasn't. They're also saying use filters. Those work. They didn't, or they don't when you don't use them correctly, and they gave no guidance on how to use them correctly. They didn't make sure everybody got them. They didn't make sure they were the right filters. They don't work when it's too high of a lead amount in the water. They were saying flush flushing doesn't work if it's not just if in your home. It doesn't work when it's a service line. In fact, it's worse when it's a service line if you flush for a while, because now you're getting the real lead from the service line instead of just what was in your home pipes.
Were these remedies made up, or did they do this for all these, whatever they are, ALEs, or, I mean, you know, was this the first time these remedies were offered to residents? And I mean, it goes more to the merits than it does to the accrual, but anyway.
I don't know, Your Honor. I'm not going to take on every ALE in the state, but I'll say this. I'm sure that these remedies do work in some situations. All I can say is that in this situation, they were not the right remedies for what was going on in Benton Harbor. And when you have water systems, what matters is the composition of the source water and what is the composition of the pipes in the system that that water is going to be going through, and what's the chemical reaction between those. And that's why the corrosion control is such an important thing to get right. And you have to do a study, and you can't just, farm it out and use some generic off the shelf. You have to do something really bespoke. So it could be that in other places that had ALEs, this did work because they had a different kind of source water, or a different kind of system. So I don't know. But in this situation, I can tell you that what they were doing, the mitigation they were saying, was not correct. And, as Levitt says, you never said stop anything in the water. You're focusing on all the wrong things, that sort of stuff. And just to go back to the point about specific contradiction, their contradiction to the Levitt email is in the Oswald affidavit, which is in the record at page 716, and on paragraph 11, he says Andrew Levitt is not a consultant hired by Eagle to provide advice regarding Benton Harbor's water system. I am not aware that Eagle has ever hired Mr. Levitt. I have no recollection of ever speaking to Mr. Levitt or seeking his input regarding Benton Harbor, and I am not aware of any Eagle employees I supervise ever consulting with Mr. Levitt. But if we look at the email, we've got this email going from Kara Cook at the governor's office to Andy Drawheim, who is the Eagle chief of staff. And then we've got him sending it to Liesl Clark, who's the head of Eagle, and she's sending it to Elizabeth Hertel, director of DHHS. Oswald's not on this email. He's the wrong guy. Where are the people that are on this email? This email is going to Oswald's bosses. So he may not know anything about Levitt's involvement, but we don't know anything about what Liesl Clark would say about this email and the hiring of Levitt. We don't know what Drawheim would say. We don't know what Hertel would say. We don't know anything about what any of these people knew about how this Levitt was involved, what they did when they got this advice, what they thought about it, whether they knew this previously. He says in the Greek letter part, as I warned, there are major red flags. Makes it seem like perhaps there was an earlier conversation with him. These are all things that we don't know. So you can't just knock out our allegations about this document by having a guy who's not even on the document say, I am not aware of anything in this document. So from our perspective, that's not an appropriate use of C7. That's not a specific contradiction as Patterson talks about. Unless your honors have any other questions for me, I will sit down. Thank you.
Gamble?
I appreciate that opposing counsel has conceded that the C7 standard does apply here. And she then walked through what a typical C7 analysis might look like, which is a careful comparison between evidence, allegations, disregarding the contradicted allegations. None of that happened here. That did not happen below. And so that's a concession from the other side that I'm happy to highlight, that what they agree should have happened did not happen. And to focus on for one example of an allegation that they really rely heavily on that is explicitly contradicted by evidence is that they insist that the U.S. Environmental Protection Agency issued an order to state agencies finding that the state agencies had misled the people of Benton Harbor and told them incorrect information in these notices. They don't attach the document from the EPA, so we do. And reading that document shows that it doesn't say that at all. It's not directed to state agencies. The only reason EPA was involved is because the state agencies asked them to be involved and come help them with this situation. The order was directed to the city of Benton Harbor and it didn't find anything wrong with the content of any of these notices, which were required by law. And those content, the EPA agrees with it. This is standard messaging that goes out hundreds of times a year all around the country. The plaintiffs are saying that violated their constitutional rights back in 2018.
Doesn't that go to the merits rather than the accrual date?
It's
Help me
both.
understand why that's material to the accrual date.
Well, because what they're saying is that the defendants had fraudulently concealed something from the people of Benton Harbor and that the EPA said that. And we're saying, no, just look at the EPA directive. It doesn't say that at all. It's not even directed to the defendants. It certainly doesn't find any problems. So there's no fraudulent concealment.
Would you agree that if there is a question of fact about fraudulent concealment, then this case has to go forward?
If a C7 analysis is completed and the uncontradicted allegations are compared against the evidence and there is a question of fact, then yes, that would mean the case goes forward. That analysis has never happened, and our argument is that if it does happen, it will show that there was no basis for them to, for the plaintiffs to claim fraudulent concealment here. There was just nothing there. And the plaintiffs, it is really kind of surprising. They're telling a very different story here in this hearing than they say in their briefs below and in their complaint, because it's not mysterious about when their claims accrued. They tell us when it happened in the complaint. They're required by statute to do that. But then there's a reason that we focus on the 4 allegations in their complaint in such detail. It's because below they said the elements, this is in page 1035 of the appendix. So it's volume 5 of the defendant's appendix, page 1035. In their brief below, they said that these 4 actions, and they highlight 4 actions by defendants, constitute an abuse of power and affirmative conduct that is sufficient to satisfy the elements of plaintiff's 2 constitutional claims, period. Those are their words. They're saying our claims accrued, those elements were present when these actions take place. That's why we spend pages saying, well, let's look at these actions. Here's the evidence showing that all of these actions they're referring to happened more than 6 months before any of them filed suit. And to Judge Murray's point about the inverse condemnation claim, there's no mystery there either. In the briefing, the plaintiffs took the position, and we explain this on page 31 of our brief, that their inverse condemnation claim arose when the contamination became public knowledge. That's their position. It's on page 1038 of the appendix. I'm not sure there. So page 1038 of the appendix, volume 5. That's what they say. So they can't stand up here later and say, actually, it's a big mystery. We have no idea when our claims accrued, because yeah, they do. That's what they said in their briefing. Their complaint says when their claim accrued. So, I mean, it's pretty straightforward from our perspective. And just to emphasize one more thing about the Mays case, that was a C8 case. That was a C8 case. So the court took all those allegations and assumed they were true regardless of the evidence. This is a C7 case. There needs to be a C7 analysis here. And if the court performs that analysis, it will find really stark contradictions between the plaintiff's allegations and the actual evidence in the case. That US EPA order is just one of many examples. And as to the email from Andrew Levitt, I don't know what plaintiffs mean when they say this was not voluntarily provided. The state agencies put up a Benton Harbor website and posted all the documents that it produced to the legislature, all the documents it produced in response to FOIA requests, so that anybody could go on there and download them. That's how this email came to light. And to say that for some reason, an outside person who had sent an email to people in the governor's office somehow triggered the accrual of their claim, I just don't see it. I don't understand. I mean, the EPA in November 2021, after this email, raised no problems with the contents of these notices because they're normal, legally required notices that go out all over the place, all the time. There's nothing unusual about that. So unless the court has any other questions, Your Honor.
So thank you very much.
Thank you.
Appreciate it. All right, that case will be submitted. Next case we will call is case number 9 in Ray DL. We have one side endorsed for oral argument, and that will be remote. Oh, and that was case number 374095.
Good afternoon, Your Honors. Melissa Calais. May it please the court. I am court-appointed counsel on behalf of Mr. who is present in the courtroom today. This case on appeal has been a little different than most of the mental health appeals that I do, in that Mr. has been extraordinarily involved with the case. I did file earlier in the case a notice of limited scope representation back on July 15th. And as I'm sure the court sees, our brief was a combination of work I did as well as work that Mr. directly did. I did receive a notice from the court indicating that they expected me as court-appointed counsel to present an oral argument today. So I am prepared to do that.
Ms. Clay,
I'm sorry,
could I
yes.
ask you to use initials rather than your client's name in oral argument today?
Certainly.
Thank you.
So I will be touching on some points that the respondent, my client, has requested that I touch on, and he and I collaboratively spent quite a bit of time preparing for argument today. I would first like to address that there are 3 claims in particular that touch on rules of law. First, one issue in our joint brief prepared by me and my respondent client is that the trial judge here essentially just rubber stamped the testimony of the testifying doctor in this particular case. The court gave undue weight to the testimony of that doctor. And the reason why that's so critically important is because the court ignored other testimony, and our position is that the great weight of the evidence presented to the court was really in respondent's favor, and yet he received a mental health order entered against him. Part of why that occurred is because the testifying doctor was relying on medical records that contained errors in those records. Respondent, on his own, as he's been quite involved in this case, filed a motion for a new trial. That was denied, but he attached significant evidence to that motion and identified multiple errors in those medical records. And to some degree, it's a little bit like a bad game of telephone if what the doctor is relying on is statements contained in medical records that are reports of what other people said, and those reports are in error, and he's repeating back multiple layers of hearsay. I don't see how that rises to the level of clear and convincing evidence to meet the requirements under the mental health code, particularly when that evidence was contradicted by the testimony of my client, the respondent in this matter. Additionally, another key point raised in the issues in the brief on appeal is the lack of ability of my client to receive an independent clinical evaluation. That is a right that is given to him by statute. He attempted to exercise that right. His trial counsel found somebody who was willing to provide that, but at a higher rate than what the court was authorizing to be paid. And the court simply instructed trial counsel to make some additional efforts to find somebody else who could do an independent evaluation at a lower cost. He was unable to secure anybody else, so the matter proceeded to trial. As my client pointed out in his pro se motion for a new trial, that was clearly error here because he's entitled to an independent clinical evaluation. The cost really shouldn't be the defining factor. There's no indication that a similar cost was placed on the prosecutor's ability to call testifying doctors, no indication of what those costs were. So to say that he's not permitted to have what he's entitled to by statute simply because of that cost was clearly a legal error in this case. Additionally, as a third point, touching on his claims relating to errors of law, This has been an ongoing mental health appeal ever since he was deemed incompetent to stand trial, yet he's apparently determined to be subject to this mental health proceeding, and the court is taking his liberty in at times involuntarily holding him in a mental health hospital, requiring him to take medications that he may not want to take. This particular court order is a bit unusual in terms of court orders I see, in that it actually requires that he be subject to the living conditions deemed appropriate by community mental health. And as a result, he had a guardianship entered against him. He's now in a supervised living situation that he frankly doesn't need and doesn't want to be under. But the court gave extraordinarily broad authority based on incidents that happened back a number of years ago relating to this incident where he was deemed incompetent to stand trial. And his liberty has really been compromised in ways that if that criminal case had moved forward, his liberty wouldn't have even been impinged as much as it is by being subject to these current ongoing mental health orders. As a result of these legal errors and the other errors that he's identified in his brief, we do believe that the only appropriate remedy for this particular court is to simply vacate the order that has been entered against him because of the accumulation of errors that have occurred in this particular case. I would also note that ever since that incident happened where he was deemed incompetent to stand trial, despite being subject to these repeated mental health orders, the statutes require for him to be subject to the mental health orders that he needs to be a risk of harm to himself or others. And that has to be proven not only by clear and convincing evidence, that has to be a substantial risk. And there also needs to be some immediacy to that risk. It can't simply be, well, in the past, he presented a risk of harm, so we're just going to keep reissuing these same mental health orders again and again and again. The statutes are very specific about being limited in periods of time. So the initial mental health order is for 180 days. Again, second order is for 90 days. And then after that, you can get a continuing order for up to a year, which can be renewed. But the fact that the statutes indicate that it's for a year means we don't anticipate that people will be under these mental health orders indefinitely. But the facts that led to the initial order many years ago continue to get recycled and continue to be reused in this particular case. So I think that this court needs to look very carefully in determining whether or not there's clear and convincing evidence of an immediate risk of harm in this particular case when there has not been any incident beyond the incident several years ago that led to that incompetent to stand trial decision. He's not been convicted of other crimes, and ever since that false arrest that led to that decision, there's been no indication that he's been aggressive toward himself or to others. I would also just ask the court to kind of very broadly consider on kind of a cost benefit analysis. Obviously, anytime mental health orders are at stake, part of what the court is trying to balance is somebody's depriving somebody's liberty interest against the benefit to the public of having additional protections. And I'd also ask the court to consider, the costs, the literal costs involved with that. Not only is there the cost in terms of my client's fundamental due process and liberty rights, there's also the actual literal cost of the medications he's being forced to take, being forced to be under this order that limits where he can live and requiring supervised living, requiring him to be under guardianship, requiring substantial expenditures in case management services, when again, there really is no basis for an order in this particular case. Had he not been deemed incompetent to stand trial and had the criminal cases simply move forward, he believes that he would have been subject to at most a very short 1 month sentence, and that here he's been under these orders for a period of approximately 5.5 years, these mental health orders. So really his liberty interests are being impinged in a way that had he been prosecuted criminally, that would not have occurred. And again, the mental health system is not really intended to be a punitive system. It's intended to both protect the public and get assistance for people who need assistance. And here, this kind of ties back into my first point of you're just simply getting these kind of recycled statements by the doctor of what was in prior statements, what was in prior reviews, and what prior doctors had said that just simply gets then put into a current mental health order. I'd also like to highlight what can happen in many of these mental health cases where a clinician says that somebody lacks insight, and really that's kind of a boilerplate that gets thrown on a lot of these cases. People should have the right to question their medical providers about, is this diagnosis accurate? Is this medication necessary? What options are available short of hospitalization? Those are questions that every healthcare consumer should be asking. The fact that somebody asks those questions should not be used as proof that they are mentally incompetent and need to be subject to a mental health order. I would also highlight for the court that.
Counsel, can I interrupt you? We're coming kind of close to your 15 minutes here, and I do have, I think we have a pretty good understanding of the issues that were raised in the brief, and those are the issues that we, of course, have to decide the case on. So, if there's anything else that you think we really need to hear, please let us know.
Sure. I'm also happy to answer any questions you have. I'll just say in a final comment then, if you don't have any other questions, that additionally, I'd just like to highlight that part of why we believe that the case should simply, the order should be dismissed rather than remanded is my client has highlighted in his attachments to the motion for remand the problems he had with the trial judge in this particular case, which also included filing complaints with the Judicial Tenure Commission before this most current mental health proceeding was in place. So she should have recused herself in this particular case, and yet she continues to enter these orders against respondent. So based on that, we would also be asking that the matter simply be dismissed rather than going back in front of that same judge to continue that same cycle that's happened again. So those are the points I wanted to touch on. Does the court have any questions for me at this time?
No, thank you very much. We really appreciate this.
Thank you, Your Honors.
So that case will be submitted. The next case on our docket is item number 10, in Ray Ogletree, docket number 376781. Mr. Ambrose, how are you?
Good afternoon. Ronald Ambrose, I'm appearing on behalf of the father in this case. A little bit of a frustrating case on behalf for the father. He was incarcerated when the case began. He did whatever he could within the prison system to help his situation. He was engaged in video visits with his daughter and wanted to be a father for this child. There was I would say, lack of effort by the department to facilitate programming for him to accomplish his goals of reunification. Testimony by father was that he would be released from prison in October of 2025, and I think the court can take judicial notice that he is now released from the Bureau of Prisons, part of their reentry program. So he's released. As he testified, he is ready, willing, and able to care for his daughter. And we would ask the court to reverse the decision to terminate his parental rights. The initial allegations had nothing to do with him. His sin was being incarcerated at the time the petition was filed. So we would again just ask for a reversal.
Yeah.
Thank you very much. That case will be submitted, but stay where you are, Mr. Ambrose. The next case on the docket is item number 11, in Ray McBride, minor, docket number 372935.
This is yeah, Ronald Ambrose again on behalf of the father. Once again, a frustrating case for father.
This one was messy, huh?
Yes, agreed on a number of levels procedurally, protracted. Case is initiated by father due to an allegation of sexual abuse. And the child is removed from the home, placed with the father, and his conviction from 15 years prior comes up to haunt him. The strange thing is, and I do a number of these, I never recall a case where a child is placed in a facility or at a foster care placement 280 miles away.
Yeah, but, so I've really struggled with this case. I've looked at it so many times now. I mean, he agreed. What troubles me about that is he agreed to that placement. Those are relatives, right?
Yes.
And he was fine with it. Help me understand, like, the gas cards. Did he agree to it because they said they'd give him gas cards? Was that contingent upon that, or is that in the record somewhere that I can find? If you don't know, that's okay.
And I really don't, because the record seems at one point they were giving him like $100. And then it was decreased to 50.
Yeah, they ran out of money.
Yeah, and yes. And I mean, he testified like on a monthly basis, to get there. It's costing him like $300, on a monthly basis. Plus the travel time, 10 hours, and then they would schedule services during the same time as he was visiting, and that was being held against him.
Did he at any point that I can find in the record complain about the placement or the lack of gas cards? Because, I mean, although I wonder, I'm trying to separate the two things in some meaningful way. Because he was okay with it at first.
Well, I kind of disagree with that, because the children were placed with him initially, and our position is they should have never been taken away from him. The reason why
he was dishonest about a very serious matter. I mean, and I understand, I've done the research on that issue. And so I don't think that I think the judge rightly didn't write him off because of that, right? She just wanted to see that he was in a different space, that he'd completed, because that issue, when it occurs at a particular time, which I believe he was a minor, right? Yes. Appropriate courses of treatment appear to be fairly effective according to data. And so she wanted some kind of confirmation that had been accomplished. And it's difficult when you have somebody that comes in and they start the case out dishonest, because then when he says, I completed that, you can't just really take him at his word, can you? I mean, it just kind of put her in a spot where she needed the confirmation. That's what I'm struggling. That's part of the struggle.
Okay, I can appreciate that. But he, upon his release, back 10, 15, whatever years ago it was, I mean, he completed courses. There's testimony recidivism rate for somebody like that is lower. The psychologist wanted him to do a particular program, Love and Logic was the program title, but he was doing programs, and it just seemed like they wanted to do him to do this particular program.
Right.
And he was, once he figured out, oh, okay, this is what you really want me to do, then, he was open to it. He never you know, was not open to doing any type of services. He wants to be a father, you know? And so, you know, I laid out, I separated it into 3 issues, but you know, you can more or less combine it into one, you know, whether or not a statutory basis had been met, best interest of the child, and were reasonable efforts made. And I think on each and every one of those.
I think I'm still struggling with reasonable efforts. Just it's that gas card in the distance. But then he was provided with other services that he didn't necessarily complete. So when did he, again, can you help me with, when did dad raise, or did he raise any complaints about the gas cards and traveling?
I think pretty much his testimony throughout was, you know, the struggles that he was having with the transportation. I mean, he was pretty vocal. I think I cited some of his testimony in the brief about, you know, and at length.
It was 10 hours round trip.
Yes.
That's what you said in your brief.
Yeah, and so, I mean, I think he was glad that they were with family, but you know, the accommodation part of it, which the judge gets into a little bit, was, okay, well, the case is initiated in Calhoun County, everything's happening, the court's in Calhoun County, why aren't the children taken from Alpena, you know, down to Calhoun County?
I mean, in these cases, what happens is they're looking, the priority is a relative. I mean, kids do so much better
Mhm.
with a relative. And if you're going to have an, you know, just if it's going to be ongoing, that's ideal. But at the same time, if you're going to be able to, if the, you know, when the goals were unification, visitation is pretty key to that. And so that's where the distance becomes problematic.
And I think he prioritized visiting, you know, with the child. And on, like, he gives an example of one time, you know, he did complain about it. You know, one time on, I believe it was the child's birthday, that he makes the trip all the way up to Alpena and then he was denied visits. Yes, the department said he didn't confirm the visit or something got, you know, miscommunicated with him. So, but you know, I put together an extended brief. I'll rely on my brief unless anybody has any questions.
Thank you very much.
All right, thank you.
This case will be submitted. The next case is item number 12, In re Henry Minor, docket number 375271. We do have an attorney endorsed for oral argument, but I don't think anyone's checked in. Okay, so that case will be submitted on the briefs. The next case is item number 13, In re MM, docket number 374725. That case will be submitted on the briefs. Item number 14, In re Jaland Minor, docket number 373612. That case will be submitted on the briefs. And finally, we have item number 15, In re Turner Minor, docket number 374024. That case will be submitted on the briefs. And so that concludes the case call for today. Thank you very much.
Excellent.